Professor Casey's most recent book is Libertarian Anarchy, Against the State, which was published last year. He has also written a book about Murray Rothbard, which was volume 15 in the series Major Conservative and Libertarian Thinkers. A paperback version of that book was made available this autumn. Both his book on libertarian anarchism and on Murray Rothbard are of course a must-read for anybody in our movement. He also has a forthcoming book on the history of political thought that he might be willing to tell us about. Professor Casey has a background in both philosophy and law. He was trained in philosophy at University College Cork and University of Notre Dame, and in law at University College Dublin and University College London. He is a very popular professor among students across political lines, and you'll probably soon figure out why if you haven't done so already. Now, if I'm more reserved in my introduction of Gerard Casey than other speakers, the sole reason would be that he is my supervisor at University College Dublin. He's Dr. Gerard Casey.
Well, good morning, everyone. I'm going to do this without the microphones, if that's all right with you. If you can hear me, please put your hands up at the back. You can? Excellent. If my voice drops for any reason, then gesticulate frantically and I'll realize what's happening. Well, it's great to be here. I'm very gratified to receive the invitation from Andrew, and it's always good to be among friends, and especially some old friends whom I know and new friends whom I've made. I just should say that when Andrew and I were in correspondence, I proposed all sorts of exciting titles and he rejected them all and insisted on what I'm talking about today. So if the talk is wonderful and charming, then it's all my, I get all the credit, and if it's terrible, he's the blame. Okay, so as long as we get that clear from the start. Okay. I was amused, but not in a good way, yesterday by the morning session on money, because that was my entry into this whole craziness, right? I was just an innocent academic wondering about money, A, why I didn't have enough, and B, what it was that I didn't have enough of, which is the more interesting question. And a friend of mine, a colleague of mine, who was interested in German philosophy, for reasons best known to him, went to Germany and came back on sabbatical and presented me with a copy of Ludwig von Mises' Theory of Money and Credit. I'd never heard of Ludwig von Mises. Sometimes I wish I still had. No, I'm just joking. But I read this book, and I read it like a page turner. Now, nobody in his right mind, no disrespect to Mises, would start with this book, right? But for me, it answered the question that was uppermost in my mind about money. And so the discussion yesterday, particularly the dialogue about whether we're going to go for gold or Bitcoin, which is really, in metaphysical terms, whether we need something that is substantial and real and tangible on the one hand, or something which is simply virtual, was in fact the question I was interested in all those years ago. And I had actually meditated writing a paper on the metaphysics of money. I'm still waiting to write that paper, okay? So yesterday's discussion sort of reawakened the fires, the long sort of dead embers of that fire for me. So many thank you for that. The talk today, to some extent, incorporates a few bits from my Libertarian Anarchy, but more so, it's a sort of sneak preview of some bits from the volume that Oscar mentioned, the history of libertarian thought, which I'm under contract to Bloomsbury Forum, which should appear, if I don't die, the strain of writing this damn thing, sometime around January or February of 2015, so about a year or so from now. Okay, so enough for preliminaries, let's begin. I hope, said Mr. Bumble, looking about him with great ruefulness, as Mr. Grimwig disappeared with two old women, I hope that this unfortunate little circumstance will not deprive me of my parochial office. Indeed it will, said Mr. Brownlow. You may make up your mind to that and think yourself well off besides. It was all Mrs. Bumble. She would do it, urged Mr. Bumble. First, I love this bit, first looking around to ascertain that his partner had left the room. I hope you get the reference. Okay, this is an old story. Okay, going back to Adam and Eve. That is no excuse, said Mr. Brownlow. You were present on the occasion of the destruction of these trinkets, and indeed are more guilty of the two in the eye of the law, for the law supposes that your wife acts under your direction. If the law supposes that, said Mr. Bumble, squeezing his hat emphatically in both hands, the law is an ass, an idiot. If that's the eye of the law is a bachelor. And the worst I wish the law is that his eye may be opened by experience. By experience. Okay. If you're invited to a garden party in Buckingham Palace, make sure to keep your socks on. Because thanks to a law enacted by Edward VI between 1547 and 53, it's illegal to stand sockless within 100 yards of the Queen. Right? So be careful. If you feel an urge to flog your carpets, do it indoors. Section 60, subsection 3 of the Metropolitan Police Act 1829 makes it an offence in London to beat your carpet in the street, attracting a £200 fine, unless the beating takes place before 8 a.m. Whatever you do, don't fly a kite or slide on ice on the street. If you do, and it annoys anyone who lives there or is passing through, you could face a £1,000 fine or 14 days imprisonment. Got the DIY bug? Well, control yourself. It's an offence, maximum £500 fine, to carry a plank across a pavement or to roll or carry any cask, tub, hoop or wheel or any ladder, hence the picture, plank, pole, showboard or placard upon any footway except for the purpose of loading or unloading any cart or carriage or of crossing the footway. I'm telling you. Thanks to a law created again by Edward III in 1313, known as the Coming Armed to Parliament Act, it's illegal to enter the Houses of Parliament wearing a suit of armour. So don't wander into the visitors' gallery wearing cuirass. Just restrain yourself, okay? And if you should find yourself in the supermarket and you're a little short, don't, whatever you do, borrow money from a stranger. Because while you may not feel like a beggar, you'll be classed as one under the Vagrancy Act 1824. Seriously. Life, the number of pitfalls is just amazing. Now, these are all trivial and nonsensical laws, which are, I presume, not enforced. All right? I haven't heard of anybody being imprisoned for beating a carpet in the street after 8 a.m. All right? So it probably hasn't happened for quite a while. But the serious thing about the laws are the kinds of things we talked about yesterday. For example, antitrust laws, okay, all of those sorts of things, much more serious. And there's a host of other laws which are socially and economically intrusive, right? And those ones are enforced, and those ones aren't funny. So just what is this law then? So ignorance of the law is no excuse, right? That's one of those things, by the way. I say here, what it says at the bottom is, what if you're ignorant of the principle that ignorance of the law is no offence? Okay, only a philosopher would ask that question, but there we are. Okay, that's second level ignorance. Presumably that's even worse. But anyway, moving on. So what's the law? Well, the cynical view says that it's for the birds, right? The sense of the dictum that ignorance of the law is no defence is to be found in the fact that no one who lives in a community can be unaware of how the basic rules for peaceful coexistence function in that community, any more than the native speaker of a language can be functionally unaware of the rules of the language. And I stress functionally because, of course, you can speak a language perfectly. Indeed, you do. You learn to speak your native language without any conscious knowledge of what the rules are. But you nonetheless know what they are, because if you're asked in certain circumstances whether something violates the rule, you will be able to say whether it does or not. So if you're discovered with a smoking gun in your hand, standing over the dead body of your mortal enemy, it's not much of a defense to say, what do you mean I can't bump off those who annoy me? This is the first I've ever heard of it. Okay. What? I can't do this? Well, to know the law in this sense, it's not necessary to be able to state it or to justify it, any more than knowing the rules of English syntax required a native speaker to be able to state explicitly what those rules are. I can know that boy, the deck burning on stood is gibberish in English without being able to say why it's gibberish. Still less is it necessary to be acquainted in terms of the law with the serried ranks of hernia-inducing volumes that grace or disgrace the shelves of law libraries. Has anybody ever taken a look in the law library at the assembled statutes? I mean, you get a hernia just looking at it, let alone taking them down, right? It's dreadful stuff. But this is to get ahead of myself. So here's the preview. This actually is a very simple talk, all right? Blame Andrew. Okay, here's the preview of my presentation in broad lines. I won't be able to talk about every aspect of it, but I hope that you will have plenty of questions. In fact, this talk doesn't come to a conclusion, it just stops. There's a difference, all right? So I'm just going to stop at a certain stage and hope that you have questions that you were prepared to ask me. So let's look then at the preview of my, and it looks like this. I want to contrast pre-modern law with modern and post-modern law along the following lines. Pre-modern law is based on reason. Post-modern law is based on will. Pre-modern law is begotten, not made. Okay? Post-modern law is made, not begotten. It's misbegotten, in fact, but that's another story. In pre-modern law, law trumps political power. In modern and post-modern law, political power trumps the law. And finally, in pre-modern law, the political situation is that we have multiple sources of authority, and the situation corresponding to modern and postmodern law is we have unitary sovereignty. Okay, all these things line up together. Now, so there are two basic approaches we can take in respect of the nature of law. You can see it as essentially related to reason, or you can see it as essentially related to will. My claim then is that for the pre-moderns, it's a matter of reason. For moderns, it's a matter of will. For pre-moderns, assent to law is an intrinsic matter. In other words, it's a matter of being persuaded by the rationality of what is being presented to you. Okay, of course, needless to say, there are coercive elements for those who if you like, disobey it, but that is a secondary matter. For modern and postmodern law, assent is largely a matter of doing what you're told, okay, under threat of sanctions. For pre-moderns, the king is under the law. Right? For postmoderns, the law, if you like, is under the king. And the king here, I mean the executive power wherever that resides. I don't mean the unfortunate monarch you happen to have at some particular time. And this, of course, is a simplified account. There are modern elements in pre-modern law, and there are so on and so forth. They're not completely hermetically sealed. Okay, so this is a simplified schema. The key point I want to make is this. The transition from pre-modern to postmodern law is mirrored by the political shift from multiple sources of authority to a notion of unitary authority. The two things go together. The political shift and the legal shift occur more or less at the same time, and they're closely interrelated. Okay. Now, so the key then to arriving at some kind of understanding of the various distinctions is that the distinction between law understood rationalistically and the law understood voluntaristically. And the distinction between matters, I'm going to talk about this towards the end, but I'll only have a chance to sketch it, between matters that are malum in se, things that are wrong in and of themselves, and things that are simply what they call malum prohibita, things that are simply matters of regulation that any society needs to regulate. I'll say more about that a little bit later. Okay, moving on. So there's the sketch. So, oops, it is not all the way. Okay, so pre-modern law, postmodern, many authorities, unitary authority. Okay. Here's the classical definition of law. It comes from Thomas Aquinas, famous section of the Summa. And it mirrors, by the way, if anybody's familiar with Aristotle and his theory of the four causes, each of these mirrors one of the causes. So you can see here the intrinsic causes. Law is an ordinance of reason and promulgated. It's a formal and material cause. The efficient cause by the person who has care of the community, and the reason for it, the purpose of the telos at the end, is the common good. Each of these things is fleshed out. Let me contrast that with the modern, postmodern conception of law. Law is a command made by the ruler. That is it. Whether it is for the good of the community, okay, is another matter. But it certainly, and very often is, for the good of the ruler and the ruling class. So, this is the key point. Law conceived of as the expression of the arbitrary will of the legislator is essentially disorderly. We use the phrase in English, law and order. The two go together. It's like ham and eggs, law and order, right? We tend to think, I mean, it seems crazy to suggest that law could be disorderly. But law simply as the command of a legislator, law as the expression of somebody's will, not necessarily connected to any ground in reason, is actually disorderly. And that is the story of modernity. That is the story of law from about the 16th century onwards. It doesn't all go bad immediately, okay, and it's not all bad all the time, but at its root, modern law is disorderly. Okay. I'd like to say that's a picture of my baby, but it's not. Okay. Now, at the stage at which it enters our historical consciousness, law is already the product of a long period of social evolution. Without common rules, human beings couldn't live together in peace, and so society would be impossible. That being so, as Hayek notes, it would have to be the case that long before, man had developed language to the point where it enabled him to issue general commands, an individual would be accepted as a member of a group only so long as he conformed to its rules. In that sense, law actually predates language. Like morality, language, and logic, law is a group phenomenon. Morality, language, logic, and law are all embedded in and constitutive of human life long before any of them are reflectively appropriated. Logic, for example, is the explicit articulation of ratiocinative rules embodied in reasoning. Grammar is the explicit articulation of the linguistic rules embodied in speaking. Morality is the explicit articulation of the socially cohesive rules. Whoops, lost where I am. Okay. They're already embodied in functional interpersonal relations. When we learn logic as a discipline, it allows us to reflectively appropriate and what it is that we do when we reason, and allows us to become better at it. We learn grammar only after we speak our language and not before. And ethics is a meaningless enterprise if we have not already grasped its essence in practice before we begin to think about it. Nobody becomes ethical by taking Aristotle's 20 drachma course. Right. So, okay, you don't need to take the 20 drachma course to know that you shouldn't kill your old man. Okay? If you do, Aristotle says, you need to be brought up again. You don't need this course. You need to go away and find an appropriate father and mother to bring you up. You're seriously deranged. Okay? Okay? Ethics courses, if you like, are for people who already understand intuitively what morality is, and it's a matter of making it reflectively appropriate. Reflectively appropriate and making it explicit, not a matter of coming to know about it for the first time. All right. Now, the law then that's constitutive of every social group hangs around one central idea, and that was that the law, this is very important, the law was not something that anyone or any group of people made ab initio. Law is not something that was made. You made drafts and you made so on, but the law wasn't something that was made. Law, says George Sabine, was imagined to be as permanent and as unchangeable as anything in nature, like a circumambient atmosphere which extended from the sky to the earth and penetrated every nook and cranny of human relationship. The old common law idea of a judge's finding the law is now regarded as quaint, as a quaint fiction, drawing a fig leaf over the judge's act of making the law. But that's not how it was regarded by those who engaged in the practice. It wasn't meant to be a fiction, but a fact. The law was there to be found. It was already there, even if it hadn't been fully recognized before. Now, the most significant social aspect of this customary law was that it was understood as being a constitutive element of the whole social group. It wasn't something additional or superfluous, but the very thing that made the group to be what it is, what it was, and gave it its identity. To be a member of the group was to be bound by that law. To reject the law in a serious and permanent fashion was to put oneself outside the law and put oneself outside the law and become, in fact, an outlaw. Sir John Fortescue, writing in the 15th century, says, the law by which a group of people is held together, by which a group of men is made into a people, resembles the sinews of the physical body. For just as the body is held together by the sinews, so this body mystical is bound together and preserved as one by the law, which is derived from the word binding. His etymology is a little bit doubtful, but we can leave that to one side. He derives it from ligando rather than legendo, which is the traditional understanding. Neither of them is correct, by the way. Anyway. The law was originally not written down, but it was embodied in the day-to-day customs and procedures by which the group operated. The historian Denis A. notes that there is no legislation proper in the Middle Ages. The place of lawmaking in modern society being taken by the interpretation of custom. That is to say, lawmaking was not regarded as being the function of a sovereign individual or a sovereign body. Now, the legacy of the so-called barbarian tribes, that's to say your ancestors and mine, to Western political thought was threefold. First, the law was supreme over all, including the king, or the executive ruler, or whatever you want to call him. And second, the office of king required either election or community recognition in some form. And third, the legitimacy of the kingship was conditional upon the king's performance of his obligations of his office. It was a contractual or a semi-contractual matter. That's not how we think of kingship from the 16th or 17th century onwards, but it was how we thought about it from about 1100 until about 1600. Now, while Roman law portrayed the populace as the ultimate source of imperial authority, this was a remote and not approximate source. And furthermore, the transfer of authority from the people to the emperor, the so-called lex regia, was once for all and unconditional. In contrast, the tribal idea was that the people were the proximate source of authority and that this transfer of authority was neither once for all nor was it unconditional. Kings then were empowered to maintain justice under law, a law that was not a matter of their devising nor simply an expression of their will. The role of the king in lawmaking in such societies was limited to ascertaining and declaring the pre-existent law, not in making it by an exercise of his own will. As a member of the people of which he was king, the king was as much a subject of the law as any other. George Sabine again writes, "The king was felt to be obliged not only to rule justly, rather than tyrannously, but also to administer the law of the kingdom as it actually was. And it could be ascertained to be by consulting immemorial practice. The king could not set aside lawfully rights which custom guaranteed to his subjects, or which his predecessors had declared to be the law of the land." So there are the three principles of political authority we have from the early medieval period. Okay, all authority is derived from God ultimately. Law representing the principle of justice is supreme in political society, and the proximate source of that authority is in fact the community. Okay, now Henry Bracton trenchantly states, there is no king where will rules and not the law. It is worthwhile citing more from this passage. He says, the king must not be under man, but under God and under the law, because law makes the king. Let him therefore bestow upon the law what the law bestows upon him, namely rule and power, for there is no rex where will rules rather than lex. Aquinas in the 13th century makes a distinction between two types of rule, which he calls royal or regal rule, and political, a distinction that was actually taken up and used a century later by Sir John Fortescue in his On the Laws and Governance of Kingdom. The government is political when the ruler is limited by the laws of the political community. It's in regal rule, by contrast, the ruler has plenary power. So John contrasts the political rule of England favorably with the regal rule of, well, France. Okay, where else? Okay, it might have occurred to you that the account given so far neglects what is for most of us the first thing we think of in all, namely the massive edicts, rules, regulations, prohibitions that emerge in a seemingly never-ending stream from our legislative assemblies. I would actually pay our representatives about 5 times what they're getting now if they would undertake, in the case of the Irish one, to go to the Aran Islands and stay there, right, and never come back. Or in your case, I suggest maybe, because it's rather larger, the Isle of Wight or some other place, okay? Send them all there. Great idea. They're worth it, right? It can hardly have escaped anyone's notice that the most common method of lawmaking in operation today is the enactment by statutes of legislative bodies such as the British Parliament or the US Houses of Congress. Many people find it difficult to conceive and to believe that such a state of affairs is historically contingent and in fact relatively recent. I know this to be the case. My students look at me unbelievingly when I tell them this. I ask them where the law comes from, and they say, well, it comes from Dáil Éireann and Leinster House. Right? And I go, right? I mean, that's not where it comes from originally. This is a new thing, very new thing, historically new thing, and contingent. And it won't always be the case, by the way. That's the good news. I will be dead before that happens, but that's the bad news for me, okay? But as Murray Rothbard notes, first, the most law, he says most law, but especially the most libertarian parts of the law, emerged not from the state, but out of non-state institutions. Such institutions have been tribal custom, common law judges, and courts, the law merchant in mercantile courts, or administratory law and tribunals set up by shippers themselves. In all these institutions, the task of the judge was not to make law, but to find it in existing and generally accepted principles, and then to apply that law to specific cases or to new technological or institutional conditions. The same was true, by and large, of private Roman law. Whoops, it easy. Okay. I remember when I started studying Roman law, I was shocked. I was looking for what would seem like the law. I was looking for all these statutes and so on. There weren't any. It's almost all private law. I was going, what's happening here? And I suddenly discovered that's not the way it worked. Okay. Anyway, now such a conception of law then runs straight into our contemporary conception. So the conception of customary law runs straight into our contemporary conception of law as something made by a body specially constituted to make it, a law which is minute, particular, detailed, complex, and largely unknowable, if not actually incomprehensible. I can remember a case in one of the Irish courts where the barrister apologized to the judge. He said, Your Honour, he said, I'm sorry, I don't know the law. To which the judge said, Mr. Murphy, nobody knows the law, right? Which I thought was revealing. Okay. Customary law changed too, of course. It doesn't stay the same, but it changed slowly and in step with the lived experience of the people whose law it was. Schloss law was essentially negative, ruling out murder or stealing another man's wife or fraud. And in many cases, I don't want to give the wrong impression that it extended beyond what we would now think of as the legitimate concern of law. But nonetheless, for example, there were many laws concerning religion and the due observance of that. But nonetheless, beyond that, men were expected to compete for the things which we regard as good. It wasn't thought to be a matter of law. It was outside the remit. So why do we need law at all? Well, if I were the only boy in the world, I wouldn't need law. And if you were the only girl, okay, thus bringing the total number up to 2, we wouldn't need law either. It'd be very interesting and it would make a good film, but we wouldn't need law. Even if we needed it, we couldn't have it. You can't have law between just 2 people. You can have agreements or disagreements, you can't have law. Because in order to have anything out of law, you need a third party. If you only got 2, you haven't got a third party. So we can have law, we must have a plurality of embodied rational beings, minimally 3, existing in proximate relations to each other in the context of scarce resources. Okay, so that's what you need. In order to have law, you need, even these people are living on their islands, they are still connected to each other. You can have law in that situation. You wouldn't need much, but you could have it. All right. Recent work in game theory has shown that responsive cooperation is an effective strategy for maximizing self-interest. That's from Scoville. Besides the cooperation and competition that is the warp and woof of normal human living, there is always the possibility that some in society will attempt to aggress against others. That is, to initiate the use of force. To prevent or minimize this aggression and to restore the status quo ante, societies develop customary law. So the function of law primarily is to settle disputes, but more importantly, to prevent disputes arising. Right? All societies put a premium on dispute resolution or, in fact, dispute avoidance. And the reason for this is very simple. When fights or struggles break out, innocent bystanders get hurt. That's generally what happens. So every society develops law in this way, and they attempt to try and preserve the peace. And that's how law develops. It's historically correct. Imagine a dispute to arise. Well, such a dispute can be resolved in 3 ways: by agreement, by violence, or by adjudication. Agreement and adjudication are peaceful methods of dispute resolution. Violence, manifestly, is not. Agreement is sometimes, perhaps quite often, possible. In fact, most disputes are settled by agreement because most people are reasonable, will make accommodations. Many possible disputes are avoided or resolved by the willingness of the parties to compromise or by the willingness of one or other simply to yield. However, agreement is not always possible. What then? Well, when both parties maintain their claims and agreement is not possible, the matter can be resolved only by violence or adjudication. Now, violence is expensive and inherently risky. It's expensive in that if a dispute morphs into an open conflict, the increase in overall wealth resulting from the division of labor and comparative advantage will diminish or disappear altogether, and that's mutually non-beneficial. Anybody know this guy? Yeah, that's Virgil, quote unquote, the Turk Solozzo, right? And as he says to the Corleone's consigliere, Tom Hagen, who was Irish, by the way, I don't like bloodshed, he said. I'm a businessman, and blood costs too much money. Okay, that's from the book. He doesn't say it quite like that in the film. Right? Blood costs too much money. People get killed and I have to pay the widows off and business goes down and everything gets disrupted. So guys, let's sort it out. Let's be, to use the Godfather's word, let's be reasonable. Let's reason together. Okay? Violence is inherently risky inasmuch as one or other of the disputants could be killed or injured, which is why one of the first causes, according to Baker, is that of a legal system is the desire to prevent or dispute feuding or private warfare. Both parties to the dispute and their neighbours therefore have an interest in its peaceful resolution. As Bruce Benson notes, even in primitive societies, the cost of violence and the benefits of order were enough to induce the establishment of recognised rules of conduct with an emphasis on individual rights and private property. And as John Hasnas notes, violence has high cost and produces unpredictable results. Human beings naturally seek peaceful alternatives. The state appears nowhere in this. It's not on the scene. Right? If you ask yourself, I'm stepping aside from my notes for a moment, just how much of your daily life is conducted with, if you like, an eye on the possible legal sanctions that will fall upon you if you behave or misbehave in a certain way? And the answer for most of us is not at all. Unless you're driving, of course, in London, in which case it's omnipresent. Okay, but leave that to one side. Okay? Most of the time, you're hardly aware of the law. We are socialized to behave towards people in the appropriate ways, and most of the time, that's exactly how we behave. The thing that controls most of our interaction with other human beings are social norms, which have at best informal but very effective sanctions, not legal sanctions. And one of the problems I was talking about to some people at dinner tonight, one of the problems with 21st century society is in fact that social norms and the force of social norms are diminishing rapidly. And the result, of course, is the corresponding legalization of what used to be the social. This is not a good thing, except, of course, for the lawyers, right? Okay. Lawyers never lose. Now, systems of customary law tend to converge on natural law. And the key principle of natural law, which is justice, which is simply a fixed, rooted disposition to give to others what is their due. That comes from the Roman law. Either negatively by avoiding acts that are malum in se, or positively by performing the requirements of solemn agreements. So on core issues and understood formally then, all customary systems of law tend to converge on the prohibition of what has sometimes been called malum in se, acts that are wrong in and of themselves. See, for example, the second tablet of the Decalogue, right, contains all of these. I can't resist this joke. Sorry if I've told you before. Moses comes down from the mountain and he says, I've got good news, I've got bad news. The good news is I've got it down to 10. The bad news is adultery's still in there. Okay. All right. The division of the law, the first table of the law, concerns the appropriate relationship that you must maintain towards God. Right? The second table of the law contains the appropriate relationships you must maintain towards your fellow human beings. And lo and behold, I often say to my students, because I teach Eastern philosophy as well as other things, if you're looking around for a better deal, you're not going to get one. Here's the really bad news. Wherever you go, you're not allowed to kill other people indiscriminately. Rats, right? Wherever you go, you're not allowed to steal other people's property indiscriminately. Hell's bells. There's nowhere to escape to, right? Every society converges on these principles, right? The last one's about coveting your neighbor's wife and his ox and his ass and all of the rest, means that if, in other words, if your neighbor has something that you would like to have, well, get your own donkey, right? Leave your neighbor's donkey alone, okay? Right? What's the problem? There are more than enough donkeys to go around, okay? So that's it, pretty much. Okay, and the content of the things that are malum in se converge on these. We all know, this is when we say ignorance of the law is no effect. You can't, in other words, under normal circumstances, you cannot get to the age of reason and not know that you're not allowed to assault people, not know that you're not allowed to kill people, not know that you're not allowed to take other people's property. Children in the schoolyard know this. Teacher, teacher, he took my pencil. What, they've been going through a law course? No, they know this, right? Okay? It's there from the very start. There's nothing mysterious about this. So, the acts then prohibited, these acts are the core of libertarian principle of non-aggression. Thus true, there is no functioning human society that permits the indiscriminate killing of one of its members. Now you might say, well, hang on a second, let's look at history here. People have been killing each other since the beginning of time, and the answer is yes. And it's fun. It breaks up boredom. I mean, really, life isn't boring much of the time, and it's much easier, as people have discovered, to steal what somebody else has worked for rather than to do it yourself. Age-old principles, right? And you might say, doesn't this contradict what you just said? And the answer is no, because formally, the prohibition on stealing, meaning I can't steal from the guy I live next door to in this tribe, but the guy 5 miles down the road is really strange. He speaks a funny language and he looks different. And he opens his egg at the wrong end. So clearly he's not fully human. So I can steal his stuff, right? And what about the prohibition on killing? Well, I can't kill the guy who lives in the teepee next to me because he's a human being, but the guy in the teepee across the way is clearly not fully human, so I can kill him. So the sad and sorry history, intermittent history of human beings, is the gradual extension of these prohibitions, if you like, which had limited universality, limited to my particular tribe, if you like, until it extends to cover the whole human race. We're not there yet, guys, I have to tell you, right? And one of the first casualties in war is the dehumanization of the enemy. It's much easier to kill other human beings if you can believe that they're not fully human, right? Call them different names, they talk funny, they look funny, okay? They kill babies by sticking them on bayonets and waving them around, whatever the story is, right? They're obviously inhuman. Okay. Anyway, so a given society may have a severely limited conception of who is to count as one of its members, but that's a material, not a formal matter. Similarly, no society permits the indiscriminate appropriation of the property of one of its members by another. And again, a given society may have an historically conditioned account of what notion of what counts as property, but some conception of property it will have. So, for example, in Eskimo society, they have almost nothing that corresponds to our notion of property. The only things they recognize as property are personal possessions like spears and harpoons. Other than that, they don't even have a communal conception of a hunting ground which belongs to a particular group. Anyone can hunt anywhere. It's remarkable. But they do have some conception of property. It is limited, but that's a material factor. Anyway, so it should come as no surprise then to find that all societies prohibit homicide, assault and theft, rape, require the making good of damage done to persons or property, even where the acts causing the damage are inadvertent. Besides the requirements of malum in se that apply to everyone in a given society, agreements also made in the proper form must be respected by those who are party to them, because of course malum in se only cover the minimum things. I've tried this, and let me tell you, it doesn't work. If you go home at the end of the day and your significant other says to you, darling, well, that's if you're on speaking terms, or hey you if you're not, okay, what did you do today, right? And you go, well, I have to tell you, I'm really, really proud of myself. I didn't kill anyone today. Funnily enough, you don't get a lot of praise for that. I know, I've tried it, it doesn't work, okay? Or you say, I didn't steal from anybody today, okay? Don't expect a lot of praise. In order, if you like, to merit praise, you have to do something more than simply not offend against the things that are malum in se. You have to do more than not kill people or not steal. You have to help an old lady across the road, even if she doesn't want to go. No, that's the classic joke, right? Okay. You have to do something, if you like, above and beyond that in order to merit praise, right? So agreements that we make with others, in other words, the boundaries of that are constituted by acts that are malum in se. But within that, of course, those are only the minimal conditions, right? In order to flourish in society, we need to get on with other people, and we need to make deals, and we need to make contracts and agreements and work together and so on. And those require specific agreements, okay, which can't contravene, of course, the things that are malum in se, but go well beyond it. But those are matters of contract, and those are matters that we assent to voluntarily. Nobody requires you to voluntarily consent to the laws prohibiting murder, okay, homicide or theft. You can't say when you're up in court, I'm sorry, nobody asked me about this. I never agreed to be bound by these laws. Nobody cares, right? Your assent is not required. But if somebody said, well, you owe me money, and you say, why is that? And you said, well, because you have more than I do. Well, unless you live in, of course, British or Irish society where this is institutionalized by the government, normally they can only make that claim upon you if you've actually made an agreement, which you failed to carry out, or whatever it might be. It has to be a matter of agreement. Right? You can't owe money to somebody simply by existing. But you owe an obligation not to kill and not to steal simply by existing. Anyway, Let's move on. Customary law then emerges from, quasi-organically, I'm almost finished, from the lived experience of a people. Legislation, which is what we have now, which is often called law, and Hayek was one of the people to develop this distinction. Legislation, by contrast, is drafted by civil servants on the direction of a cabinet or executive power, legislated by Parliament or House of Congress after a debate, if any, okay, which in a modern democracy is tightly controlled by the dominant government party. Promulgated by a king, queen, or president and enforced by state-controlled police in state courts. The citizens in latter-day democracies have little or no say in this legislation, and their only function is to obey it, ultimately under threat of sanction. That's modern law, which is disorderly. At best, they have the power to change one particular group of legislators for another at specified intervals, but they have no power to change the whole framework. At the last general election in Ireland, I went to the ballot box. I spent 15 minutes in the booth. Everybody was wondering what I was doing. Okay, aren't you supposed to just mark your paper and come out and drop it in? No, because I wrote in mine and I said, dear candidates for election, okay, you cannot represent me. In fact, I don't want you to represent me. I would like you to get an honest job and other things. So I had a great time writing this out and put it in the ballot box. Okay. Needless to say, it did nothing to change the system, but at least it relieved my feelings. Okay. Okay. Lysander Spooner once remarked that a man is no less a slave if he gets to change his master once every 5 years. Guys, it makes no difference. Just because you have another master, you're still a slave. Okay. Now, what justification can there be then for legislation? Because I'm not counselling sort of suddenly deciding, oh, what the hell, driving on the left in the UK is after all just a matter of legislation. There's nothing intrinsically wrong about it. I kind of feel artistic this morning. I think I'll drive on the right. Okay, wee, fun as you go along, right? Brilliant. Well, insofar as it conforms to natural law, legislation is odious. While if it diverges from justice required by natural justice, there's likely to be a law permitting, or prohibiting rather, non-aggressive but morally disapproved of conduct, disapproved of as that is by other people, a law delineating some offence against the state. Do you ever notice how sensitive the state is? How frequently it is offended? Okay, quite an interesting thing, okay, especially for a non-existent entity, right? Okay, or a law permitting the state to interfere with your liberty or your property. Laws, we'd all be much better off with that, by the way. If the law is intended to change by force the behaviour of others of which the legislators disapprove, that is, to impose a particular morality or economic policy on the people at large, it seeks to substitute the opinions of the legislators, who, as we all know, of course, are all wise and all good, okay, for those of the social participants themselves, presumably on the basis that they know better than you what's good for you. You know why I'm a libertarian? I had a mum and dad. They were great, okay? And when I was growing up, it was really necessary that they told me on occasion that things weren't good for me when they weren't and were good for me. But they've passed on. I don't need another mum and dad. Actually, I can look after myself. I can make those judgments. Some of them are good, some of them are bad, some of them are wise, some of them are foolish. But you know what? I'll benefit from them who are wise, and I'll take the consequences if they're foolish. I know, for the most part, what's good for me. And here's the news, so do you. So do most people. Funnily enough, 650 people who are drawing extraordinary salaries now to be increased by 11%. Okay, it's not cheering thought. I can see Andy smiling at the back. Okay, they know what's good for you. They have your interests at heart. I'm always reminded of the words of Ronald Reagan, the 10 most feared words in the English language. I'm from the government and I'm here to help you. Yes, anyway, I'm almost done. Well, however well-intentioned legislators might be, and they're not always well-intentioned, they lack the requisite knowledge of the dispersed information. We all know this, okay, from so on. They just simply can't have it. Even if they were the best-intentioned people in the world, they couldn't do the job. By and large, even though I'm cynical about them, by and large, most of the people who are legislators, are MPs or TDs in Ireland, are actually not really bad people. They're not intrinsically malign, right? They're just really misinformed. God help them, right? Okay. They are motivated by a concern to do good for other people. Anyone who feels the urge to do good for other people should really be locked up. Okay, it's not a good idea, right? I mean systematically. I don't mean the occasional kindnesses you do to people and so on, but who sets out as a policy to do good for other people. Very dangerous. The road to hell is paved with the good intentions of legislators. Anyway, in drawing a sharp contrast between legislation and law, I don't want to be taken either to demonize the contents of legislation, which are sometimes accidentally good, or to romanticize the products of customary law, which actually are sometimes bad, because there's a lot of status elements and things we wouldn't approve of, right? There. While attempting to give expression to the basic requirements of justice, customary law can fail to do so adequately and can embody individual and systematic biases. So too, it's possible for a particular piece of legislation, for example, statutes prohibiting homicide, to embody rules which are perfectly acceptable in and of themselves. However, one is generally expressive of order and reason, and the other is expressive of an arbitrary will, and thus is disordered. If it's ever ordered, it's only accidentally so. Okay. It's likely that many questions, more questions have been raised by this presentation than answered. That's what philosophers do for a living. Okay, we ask questions. God forbid that we should ever answer them, right? Some will concern themselves with the nature of authority, the nature of representation, the nature of law and morality, the relation between law and economics, between liberty and license, between legal constraints versus social constraints, and so on. And I will be very happy to attempt to answer, I'm not sure, I can't guarantee that I will, any of your questions or respond to any of your comments. Thank you very much. Silence to all. Okay, we often have that effect, yes.
Why do you suppose people have put up with the degradation of their law from something that was absolute to something that's legislated?
It's the boiling frog syndrome. In other words, if you drop a frog into boiling water, it jumps out, right? However, if you put a frog into a pan of water at normal room temperature and you increase the heat slowly, it stays there. We're all boiling frogs.
That's a myth. The frog actually jumps out anyway.
Yeah, I know, but it takes a lot longer, right? Okay. So the changes are gradual, okay, but people are largely passive, okay, in their thing. In other words, people will put up with a whole lot before they will actually change, make radical changes. Why? Because we like stability, okay, and very few people are energetic. And despite, I don't know if you ever noticed, the number of people who actually complain are sizable for anything, but the number of people who actually do anything is quite small. I remember once talking to an opinion writer in the Irish Times about a particular project we were doing together, and he said to me that I was talking about some of the early material. He said, "Oh, we got a huge response to some of those early articles." I go, "Really?" He said, "Yeah, we got 10 letters." And I, what? I thought like 5,000. He goes, no, 10. Because the number of people who think they've written to the paper or actually done anything is usually much smaller than the number of people who actually do. It's a bit like the definition of a classic. You know the definition of a classic? A classic is a book everybody thinks they've read, but very few people have. Yeah, it's the same idea. So the number of people who actually will do anything is tiny, right? So you need a radical or a sharp change, a dramatic change, in order for people to get the energy to get up and do something about it. If the change is gradual and slow, then it becomes normal. And from teaching this material to my undergraduate students, when I tell them what I actually believe, I say, look, the purpose of this course is to demonstrate one fact and one fact only, that the state has become to know and love it as a criminal organization. And by criminal, I mean this in an absolute literal sense. It's not hyperbolical, it's not, and so on. I simply mean it's a criminal organization in the same way that somebody who steals your wallet is a criminal, and so on. They are absolutely shocked. When I try to demonstrate them that the state as we know and love it is a recent invention, they find it hard to believe. When I tell them that law as made by legislators is, if you like, a recent invention, hardly more than 2 centuries old, they cannot believe this. This is what I call the tyranny of the present. In other words, whatever we are used to, whatever we have come to know now, we believe in some sense to have always been the case, even if we know in another part of our mind that it actually hasn't. And I make this point because I say if things have been wildly different in the past, and the present is now very different from the past, then we have every reason to believe and hope, you can see where I'm going, that the future, right, will be very different from the present. right? And there are already signs. The nation states are already struggling. The superstates, unfortunately, are getting sort of larger. The EU doesn't make me happy, okay? But I very happily see the dissolution. By the way, I would like to see the devolution of the EU back into its nation states, and then the devolution of the nation states into their constituent parts, okay? And those parts into counties, and counties into baronies, and baronies into localities, localities into streets, and streets into households, and so on until we get all the way down. I won't be alive to see that, but I think it will happen.
Sorry, that's my answer to your question. Yes. If I understood you correctly, you were basically saying that this shift from law being discovered to being dictated happened in the 1600s.
Yeah, I mean, obviously, it didn't happen on any given day. It's a process, right? Yeah.
I was wondering if you could talk a bit more about the causes and mechanisms of that shift was.
Well, it goes hand, as I tried to indicate very briefly here, it goes hand in hand with the political changes. Right? So there were two major events. One, probably the most significant event was the Reformation, because the thing that united Western Europe was its religion, right? Even though there were differences and occasional flare-ups here and there, the thing that held everybody together. In fact, so much so that to describe somebody as a Christian was almost a synonym for simply being European. In other words, you had Christian values or whatever. It wasn't used in any. It was just normal. If you lived here, that's what you were. There were already signs of political fragmentation in the political sphere, right? So the beginnings of something like the modern nation state are already present in places like France in the 14th century. It was already there, right? So what happens is we have a possible fragmentation happening political, right? And so on. And then in the early 16th century, 16th century, okay, we get the political breakup, and it's explosive, and the two come together, right? And it happens. So the beginnings of modern absolutism are already present there in France. And suddenly, the only force that could counter it, which is the church, the only, if you like, multinational or international organization which could counter it, simply disappears. And in all countries, by the way, not Protestant countries, but Catholic countries as well, the church becomes a department of state. It's internalized. It's domesticated, right? And suddenly, the two, you're now to my sort of big thesis here. I believe that what makes Western civilization unique is the fact that from its beginnings, which by the way aren't in 500 BC or 800, but around about 1050. Okay, that's the Berman's thesis, right? From about that time, there have been two major poles, the tension between which creates the space for freedom, right? And there was a dispute between the pull or the tug that your political masters had on you, whoever they were, dukes or counts or whatever they might be, and the church, right? And they were always fighting with each other over who controlled what. But the great thing was, when they were engaged in this fight, you actually had a certain amount of freedom to play one side off against the other, right? Now, no other culture, this, by the way, this is not a culturalist assumption, that seems to me to be a matter of fact, has this bipolarity. So if you look at China, for example, China has been a united state in one form or another since about 500, 400 BC, right? The emperor changes. But all you do is you just get another man in the same spot. The organization, the control has stayed the same. The Communist Party comes in and the emperor goes out, nothing changes, right? It's the same, okay? But in the West, because of this accident, if you like, between the sacerdotium and the regnum, okay, we've had this tension. Now, what happened then is in the modern period, because of the fragmentation, the political fragmentation and the religious fragmentation coincided, right? We suddenly have the emergence of the modern state and the development on the Jean Baudin in the 15th century of the notion of sovereignty, right, which again is a historically contingent idea, right, one that would be absolutely almost inconceivable to a medieval. They couldn't have understood because they had multiple sources of authority, not just one. But the idea that there should, in any one area, in one state, be a single source of authority, which was all in all, is a modern idea. It's a new idea. It's a ghastly idea, right? But it's a modern idea. On the other side, we had people, at the same time, we had people like Johannes Althusius in northern Germany, in the town of Emden, okay, in East Friesland, okay, coming up with a sort of federalist idea, which is a continuation and a modern version of the same ideas that you get in the medieval, but sort of modernized. And so, but unfortunately, the realpolitik at the time was such that the Bodinian notion, if you like, won out. And the Althusian notion disappeared completely until rediscovered by Otto von Guericke in the late 19th century. And that's what we've been living with in the last 400 years. It's beginning to be chipped away, but it's still dominant, and it's still the kind of idea that everybody will have. If you scratch at the surface, they will say, but of course we have to have authority. Of course there can only be one source of authority in a state, and it has to cover all the, up to the boundaries and so on. But when you tell them this is a new idea, historical idea, they're completely unbelieving. Yes.
I would argue that the United States, in its original form, really embodied pre-modern law in that it was all about depowering the center of the state. Purpose of the Constitution is to limit and control power of the state. So I think the pre-modern law, at least in the United States, was very much alive in the early 19th century.
My heart is entirely with you. My head is slightly against you. Let me say why.
First of all, the US Constitution is one of the noblest and most gallant attempts to set up a minimal state.
Precisely.
It is a gigantic failure. Alas.
But it wasn't original.
I know, that's the point. And the point is, despite having set it up explicitly and written it down explicitly, right? Nonetheless, we are now where we are. It is absolute, sorry?
It's a good lesson.
It is a good lesson, which is the point that political power and sovereignty and control is an untamable beast. You cannot control it, right? You think you can, sorry?
I disagree.
Well, I think well, again, I mean, okay, we're in the zone, but I think if you look at this one, we've had this is the classical case. We've seen it progressively. You might say, well, there were contingent historical events, the Civil War and all of the rest, which led to it and so on. We could argue about it. But in the end, in fact, the best effort to do this has failed. But let me come back to the point about pre-modern. It's not entirely that, because remember, the states which make up the United States were themselves political entities, right? And so the states.
They were also
Constitution. No, I understand.
Several states
Yeah, no.
also have the same features.
Yes, I know. I appreciate that. So I don't want to be understood as, I mean, I think, let me put it this way. If you had a button in front of you right now, right? And by pushing that button, we could get to something like a political system operating on those principles, and you said to me, Casey, would you push that button right now? The answer is, I would be there so fast you wouldn't see me move, right? It would be such, by comparison with what we've got, it would be so great. My finger would be glued to that button, and I'd be pushing it repeatedly. Yes, yes.
Yes. So, yeah. Yes. Sorry, but tell me when to shut up, by the way, because I'll go forever.
Okay. Well, when the Ten Commandments were on the screen,
Yep.
you mentioned you know, those are generally the rules for all societies. You can't owe money just by being alive. But couldn't one argue that many societies, you do owe money by being alive if you're successful, especially if we talk about families or tribes. They are redistributive, and they want to be redistributive, and that's perfectly natural for them. And then the libertarian conception of property rights would be more of a choice than a moral imperative.
No, that actually is a very good
Point. I did make the point that the Malamans say and so on are the minimal conditions, and people make agreements, right? So, but when you're born into a society, you're born into a society in which there are, if you like, large-scale rules for association. So, for example, if in a hunter-gatherer society, if it takes cooperative effort to kill a large beast, for example, then there are normally rules for the distribution of that in some kind of proportional way, right? And that is their law. So, yes, I'm not saying that the only content of customary law are the things that are Malam and say, no, that's not true, okay? But let me give you an example how it would differ. So how it could differ depending on the material circumstances. On these islands of ours, right, if you have people living together and engaged in agriculture and pastoralism, right, then if you're growing crops, you don't want your neighbor's cattle coming in and trampling all over your crops, right? So the rule here is if you have things like large animals in your property, you have an obligation to fence them in, right? So in other words, you must contain your animals, right? But If you go to the American West in the 19th century, right, where you have a situation where you have wide open ranges and cattle all over the place, and then people start coming in on the margins and creating farms and planting crops, okay, if they had the obligation to fence their animals in, you would have strings of wire going from, I don't know, Dakota, okay, coming all the way around, and so on and so on. It simply would be impossible. So you change the law, right? You keep the same principle, but this time the obligation is that if you want to grow your crops and you don't want them damaged, you have an obligation to fence the animals out. Right? Now the same result is achieved, but the obligation is shifted depending on the material circumstances. You get the same differences regarding the rights to water and distribution, riparian rights and all of those, depending on the circumstances in which you find yourself. And yes, every society will have those, and some of them will be redistributive, so that everybody in a tribe will get something from the large animal, whatever that might be. Okay, but then everybody contributes in some way. It's like a community effort, communal effort, and there is, in a sense, a tacit agreement that is in fact.
So if you seriously object to it, in fact what you do is you simply take your teepee and you move away.
So Peter has been waiting for a long time?
Professor Casey, can you elaborate on the distinction between judges finding law in the common law process and what Americans would regard as judicial imperialism, judges just making up the law, as for example with Brown or
Yeah, okay. That's a very good question. So in other words, can I distinguish
between judges finding the law and between judicial activism? And the answer is no, it's a fine line. But judicial activism is judges, okay, judicial activism comes around, normally, these are the circumstances, where there's a politically hot topic. The legislators, for whatever reason, don't want to get in trouble with their constituents, right? So they consistently refuse to legislate on the matter, but wink, wink, nod, nod, okay? They let the judges know what they would like them to do, and in a situation where the judges can, like where a case comes up, the judges, of course, in our system are creatures of the government as well. They're a government institution. And surprise, surprise, right? Very often, when the case comes up, then a judgment comes down, which, believe it or not, is precisely what the legislators would have liked to legislate for, but now they can say, nothing to do with us. The court has decided, right? So that's a different thing, and that's a kind of a post-modern development. But the judges in the common law system, by the way, and the common law system wasn't perfect, by the way. It itself, under Henry II, was an effort, if you like, to suborn the local law administrations that were already present in England at that time. But even within that, it wasn't that. In other words, the judges were simply presented with a case, and the features of which weren't, if you like, subsumable under any existing principle. Right? So they went back to first principles. They're not responding to a political, an unspoken, wink, wink, nod, nod, political dictate, at least not all the time, right? So by and large, they're simply doing that. So that's finding the law. They're going back to principles and saying, well, I mean, if one party injures another, where will the liability lie, to what extent, and the case doesn't cover it. So let's take Rylance and Fletcher, a classic case in tort law, in English law. In Rylance and Fletcher, you have a situation if one person causes damage to another, right? Then, suppose I bring onto my property lions or tigers or whatever, and like the Marquis of Bedford or whatever, and I have a zoo, or I conduct like a huge reservoir of water on my property, and it escapes and it causes damage. Well, the principle then in tort was that if you change the sort of normal disposition of your property in some sort of spectacular way, and as a result of that damage occurs, you will be liable. Now, that principle in English law comes from that particular case, hence the name. It's Rylance and Fletcher, right? And that would be, so when the judges were presented with this in that case, they didn't have a principle to go on, right? They didn't have an existing norm that they could subsume it, so they had to think about it, if you like, from first principles again, and they made a decision on that basis. But once they made their decision that way, and then that became a principle in English law, and then law proceeds from it in that particular way. So that's an instance of finding the law. But what you find, for example, in Supreme Courts, American or Irish, as the case might be, very often
is the case of them making it up.
Well, for example, what do you think about Brown versus Board, the Board of Education, the desegregation decision? I mean, is that a found law? Obviously, it was a break with anything that was the precedent, and it was a break with what the legislature apparently wanted at the time.
Since, well, again, I'm going to start historical rounds here, okay. But certainly,
in the 20th century, and certainly in the post-Rooseveltian Supreme Court in the US, okay, I would suggest, again, I'm intending no disrespect to individual justices and so on, I would suggest that the court, especially the US court, has become more and more politicized and more susceptible to understanding what it is required to do to bring about social change, which social change cannot easily be made by the legislators for particular reasons. Whether you think the result of that is good or bad.
That was happening way before Roosevelt.
Yeah, I know. I know that. Indeed, yeah. I'm just picking that point. I could go. That's why I'm saying I didn't want to start a row. So I thought that was like a time after which we could all agree on it. Okay, if we wanted to go back, we can. Yeah, I'll go back with you. I'm happily go back with you. You're not going to get a disagreement from me on that one. But yeah, but certainly from that time, that's what I think happens. So look, there are questions, but I'm happy
to stop already. Brilliant. If that's good, we break for 5-10 minutes, and then you got one more.
Yeah,
one more.
The way you presented the evolution of law, it seems to me that you're presenting as sort of a case for path dependency, that there is very little role for human agency, and this is just the overall process that happens, and there's little we can do. And the second one would be whether customary law or the earlier law is really an alternative to in postmodern or post-industrial society.
Well, those are two questions, two very good questions. The first one concerns whether or not I'm making an assumption about path dependency, and the second one is whether, even if what I said were true and all of the rest, whether we could, as it were, go back in that particular sense. So did I get you right? Okay, very good. I'm not sure how to answer the question about path dependency, because the issues here are not, if you like, issues of what individual people do. These are, no one person, if you like, made a decision to go in one particular way. These are large-scale historical events that individuals obviously contribute to. History is not independent of individual decisions and so on, but no one suddenly, made a decision. It's not like, again, as if in, when did the Roman Empire, Western Roman Empire fall? I can't remember, 484. Somebody once said, Roman Empire now out of business, apply to barbarians incorporated, okay? These things don't happen overnight, okay? I mean, nobody knows. Nobody suddenly woke up and said, "Oh, we're now in the Middle Ages, or we're now in the Renaissance." Yippee, the Renaissance started yesterday. Okay, this doesn't work like that. So I don't know how to answer that one. My guess is that I'm not dissing, I'm not disrespecting individual human action, but again, we all know from practice that there are times when, no matter how good you're thinking and how brilliant it is, it simply makes no way. So the example I gave Johannes Althusius, I think his way of thinking was brilliant. But the times in which he produced it were such that it could make no progress. The new state and all of the power relations and all of those were already in place, okay? And he's simply some obscure North German town, they simply ignored it. The second question was again on, oh yeah, in other words, can we go back? And the answer is no. No, we can't go back in that way. And I made a quick, probably too quick passing remark and said there were large-scale aspects of customary law that we simply couldn't live with. So one of the things, for example, that customary law systems have is they're largely status-based. Okay, so they make distinctions, in other words, between types of human beings, and the law, even when they have it, even when it's hands-off to the extent that it is, nonetheless applies differently. So, for example, if somebody has a noble status as distinct from plebeian, right, and you kill them, it's going to cost you a lot more. Right. On the other hand, so if you kill a noble, you're going to die. Okay. If you kill a slave, well, easy come, easy go. Right. You pay a fine. Right. There's no way that a libertarian could accept those kinds of principles. So I'm not suggesting going back. I'm suggesting recovering, if you like, what I think are essential to the libertarian aspects of that, and making that the core content of any law, right, in society, which would transcend any particular society. Every society would, in fact, sign up to that, right? But it's not even a matter of signing up. There's no way they could exist. You could try it. You could have hippiedom incorporated, okay, and we've decided to abolish the second table of the law. Well, it won't be there very long, right? If you can kill other people in your community indiscriminately or steal their stuff, well, it's just not going to survive. So these are the conditions for survival. But beyond that, right, in my libertarian vision is that any society can incorporate itself in any way it chooses. And the people who want to belong to it can sign up to any set of regulations that they choose to set up, including exit conditions, by the way, if they want to leave. Right? And some of those would be conservative, socially conservative. I would belong there. That's me. Okay? Others would be, I don't know, whatever you have in yourself. Let's all hang out and paint our Volkswagens, okay, and so on, or whatever it might be. And that's fine. And that's great. Right? And then we would see what would happen. Some of those would survive and some wouldn't, and you might change your mind and move from one to the other, and that's great in a libertarian society. So it's certainly, I'm certainly not proposing a one-size-fits-all grey doer world. My libertarian world would be an exciting place to live, in which there would be real differences, and the differences that made a difference would exist.
Thank you very much.
Thank you very much.
So, we are ready to start again. The next speaker is Sebastian Ortiz, all the way from Costa Rica. He's a translator and a businessman who has got the attention from the ultra-libertarian community through videos where he explains his views on, for example, the principles of libertarianism. There's no doubt that his knowledge is deep and wide-ranging. He became a hardcore libertarian anarchist in the tradition of Rothbard and Hoppe after exploring and considering a whole range of ideologies. A noteworthy fact about Sebastian Ortiz is that he descends from the first head of state in Costa Rica, and his family has an interesting history, a material for a biography that Sebastian will hopefully write one day. The title of his talk is The Anti-Science of Moral Skepticism. Please welcome Sebastian Ortiz.
Thank you. Thank you, Andy, for having invited me. The past 3 days have been some of the happiest of my life and most stimulating. I am not a proper scholar, so I will not be defending my views. The sources are obvious, and so it is left to you to discern whether they are correct. And I might extend myself into the questions period that I am allotted. Epigraph. The classical view of knowledge is a justified true belief. Critical rationalism denies that justification is possible. Jan Lester. Let me begin by making reference to the etymology and meaning of some relevant terms. Science, from the Latin knowledge, that which we know about the world and man, discoverable through inquiry and rational reflection, separate and different from research and experimentation, the methods through which the quantitative aspect of theoretical inquiry, such as comparison of constant processes, which require precise measurement, is carried out. Science is separate and different from history or the succession of particular events and recorded contingencies. The Greek word katholikos means universal, a contraction of kataholu, meaning derived from the whole. Religion, from the Latin religare, to bind together. The etymology of religion refers to a binding body of work that serves as the basis for a worldview and a system of ethics. Fact, from the past participle of facere in Latin, to make, to do, from factum, deed or done. A fact is a valid construction about reality. While state-funded intellectuals in a linguistics department might look upon us with suspicion and object by appealing to the Sapir-Whorf hypothesis that states that language molds thought and that by conjuring definitions, libertarians attempt to slyly attain unwarranted agreement, I am inclined to retort that this is ridiculous. The very purpose of definition is precision, and definitions are valid insofar as they describe real phenomena. Having said that, I just wanted to bring up these definitions as I find that they provide valuable historical and semantic context. Now, from Aristotle's Nicomachean Ethics, I quote, "Induction supplies a first principle or universal. Deduction works from universals. There are first principles from which deduction starts, which cannot be proved by deduction. Therefore, they are reached by induction." End quote. This, of course, involves the category of mind or the a priori of causality, also known as pattern recognition or causal inference. Therefore, we can more or less refer to science as a compendium of cause and effect patterns about the world, and man grounded on irrefutable facts or valid constructions about the world. Allow me to disagree with Mises when in the introduction of Human Action he states that, and I quote, "Science never tells a man how he should act. It merely shows how a man must act if he wants to attain definite ends." For this statement is at odds with his concern that, and I quote, "It must be emphasized that the destiny of modern civilization as developed by the white peoples in the last 200 years is inseparably linked with the fate of economic science. This civilization was able to spring into existence because the peoples were dominated by ideas which were the application of the teachings of economics to the problems of economic policy. When, as demonstrated by Rothbard in Man, Economy and State, the very kinds of action that make the subject matter of economic analysis, such as exchange, selling, buying, lending, renting, carry the implicit assumption of the functional validity of private property. If a concern for Western civilization and the market economy will be expressed, this will invariably lead to the acceptance of peace, defined as the absence of aggression against property owners, as a valid, definite, ultimate end. It is via the influence of Aristotle, who Aquinas referred to as the philosopher, that the Thomist notions of universal natural law were developed. Aristotle briefly mentions the notions of natural justice in Book 5 of his Nicomachean Ethics, and I quote, "All that is unfair is unlawful, but not all that is unlawful is unfair." And that, quote, "Some think that all justice is of this sort, because that which is by nature is unchangeable and has everywhere the same force, as fire burns both here and in Persia. Similarly, the things which are just not by nature but by human enactment are not everywhere the same, since constitutions are also not the same, though there is but one which is everywhere by nature the best. The notion of a universal moral code based on the nature of the world and of man was first developed in the Fertile Crescent, where the major civilizations and religious schools of thought developed, such as Zoroastrianism, Judaism, Christianity, the Code of the Pashtun in Afghanistan, and even the Nyaya, literally recursion school of Hinduism, makes reference to epistemology and logic as the basis for its teachings. It has been argued that due to the hunter-gatherer-agriculturalist divide, we see the development of conflict avoidance rules in those areas where survival was intricately tied to a sedentary location. Property rules, such as the homestead principle, are bound to arise if your survival depends on a plot of land and the crops and animals that live on it. This emergent order should not be confused, however, with the notion of a rights theory grounded on the nature of man. It is in this historical context of Indo-Mediterranean and continental civilizational development that we can perhaps best understand why Christianity became identified with universalism or Catholicism. It is in this context that Rothbard, via Thomas of Aquinas, via Maimonides, via Aristotle, formulated libertarian political philosophy. From the finite nature of resources and the possibility of disagreement or conflict arises what Hoppe has termed the problem of social order, or the necessity for the establishment of social rules determining who has legitimate title to exercise exclusive use over a given resource. One could say in hindsight that more or less coincides with a rationale Hobbes gives to justify the state, namely to prevent a war of all against all. The answer, though, lies not in a centralized monopolist of protection and decision-making, but in a universal moral theory of political organization and in the acceptance and enforcement thereof, a theory of property and a theory of what aggression entails. Like any ethical theory, it must comply with the universalization requirement, also known as Kant's categorical imperative, the notion that rules must be general and universally valid for all persons. Implicit in the establishment of ethics or political philosophy is the desire for peace, or the absence of aggressive conflict, as the exclusive and ultimate common goal or end to be achieved, and the acknowledgement that this is the first necessary condition for individuals and groups to be able to pursue their own ends. This is what anarcho-libertarianism is. It is an ethical theory, and as such it tells us what should be done. It is a moral theory of political organization, and as such it tells us what must be done, or rather what must not be done, namely the initiation of force against property, including persons' bodies. It puts forth what rules are legitimately enforceable, such as the defense of property. As such, libertarianism is grounded on our knowledge of man in general, specifically on our knowledge of man as an actor, and in our knowledge of the world in relation to the actions of man. That is, our knowledge of the fact that there is scarcity or the finite nature of useful economic resources. It is based on this knowledge and in the general, universally applicable aspect of the theory that we can say libertarianism is a scientific system of values, that is a rationally justified and realistically grounded theory of which ultimate ends should be pursued, namely peace and property, in that specific order. As once peace is established as the ultimate goal, our economic knowledge will show that private property is a fundamental requirement for its attainment. Ideas are either arrived at through rational inquiry and reflection, or as a result of emotional reaction, ulterior motives, as influenced by history and culture. I have briefly touched upon the cultural and environmental precedents that in the Fertile Crescent led to civilization and universalist systems of ethics, culminating in Christianity's influence on Western culture, and the development of concepts such as that of equality before the law. All of these influenced Rothbard and Hoppe's rational justification of anarcho-libertarianism, as grounded in the nature of man as an actor and in speech or argumentation as a category of action. That is, a category of purposeful behavior directed at the materialization of specific abstract goals. Let me now briefly talk about the psychology and history and motivation of cultural Protestantism in its secular and religious forms and its philosophy of science. I am not a Catholic. However, after listening to a lecture by Hoppe, I became convinced that for freedom to perdure, a universalist, absolutist culture that is comfortable with inequality, and an ornery population of dogmatic property holders with a black and white sense of what is right and what is wrong will be necessary. Since the end of Southern European geopolitical hegemony, that is, since the end of the Roman Empire, the Catholic, Germanic, Holy Roman Empire, and the transition to the British American empires becoming the hegemonic world power, state scholarly funding has moved towards the Anglo-Saxon Protestant sphere. And so the notion of what entails science and scientific discourse has been twisted and constrained by a now formalized positivistic ethic, so that science has come to mean research, experimentation, and pseudoscientific objectivity, yet with anti-scientific dogmatism as a result. Erich von Kuno-Ledin has discussed extensively in his book Liberty or Equality how Protestantism can be seen as an anti-rational reaction to Catholic aristocracy motivated by goals of political centralization towards total power, expropriation, and fueled by populism. Lutheranism, with its solace or the notion that through grace, faith, or scripture alone is salvation attained, shows the psychology of fanatic fundamentalism and moral upmanship. Direct revelation, permanent schism based on particularistic and historically consolidated via consensus rather than universalist interpretations of the Bible, and condemnation of opponents, literal adherence to scripture or data, yet open to free interpretation or peer review, radical ignorance, and anti-rationalism are the three main characteristics of cultural Protestantism. Another aspect of cultural Protestantism is its radical and militant egalitarianism. The notion of direct and immediate revelation was most markedly present in Britain, where sects such as the original Quakers, Levelers, and Ranters claimed to have a direct individual connection to God, such that no intermediary or hierarchically appointed expert was necessary. Thus, the Quakers had women ministers, but no appointed clergy. In its most extreme form, this notion resulted in the Ranters, who can be described as antinomian. This egalitarian aspect also implied a superior connection to the Gnostic God. Why go through the middlemen of the Catholic Church, the priests, the educated priests, when you could simply achieve equal results through direct revelation? Although to a secular audience in this century such an insight might seem of little relevance, its philosophical consequences become evident when one analyzes the peculiarities of Anglo-Saxon philosophy of science, that is, the school of empiricism. Today, we are told that in science, conclusions derive from the data and experimentation, and that this purely data-based analysis, plus the consensus of peer review, makes empirical conclusions superior. Only as mere passive spectators of data and reactions can we honestly come to know something. While this might seem a harmless standpoint, the implicit notion here is that by way of a lack of theoretical constraints or necessary assumptions, we can rely on the data alone to yield value-free or verify conclusions. Yet the very concept of experimentation with the aim at pattern identification tacitly carries within itself the a priori of causation, or causal inference. In its particularly British form, cultural Protestantism has two main consequences. One is that of radical ignorance as a form of moral superiority, or the unbiased observer-historian theory of science. The culmination of radical ignorance as moral superiority takes place in the form of the rejection of the principle of sufficient reason by David Hume. We're told that just because the sun has come up at dawn every day, one cannot reasonably assume that there is a permanently operating cause and that therefore tomorrow the sun will come up at dawn. Or rather, that such belief, however evident, is not rationally justified. Such notions were taken further later by the works of Karl Popper's philosophy of science, that says that all knowledge is hypothetical and subject to later reinterpretation. The logical positivism of the Popperites precludes the possibility of scientific knowledge, that is, universal certitude, as it claims that all knowledge is hypothetical, and therefore it cannot be assumed to be knowledge, provable or disprovable, but as mere speculations which at best have not yet been falsified, mere conventions. The second most significant contribution of cultural Protestantism is that of the value-fact dichotomy. According to Hume, a rationally defensible ethic based on the nature of man is not possible, as it would compromise a spectator-only theory of knowledge, and as such any ethic would necessarily suffer of the inevitable bias from the difference in values or opinions among men. Suffice to say that I disagree with this position. I would like now to refer to a recent presentation by Hans Hermann Hoppe at the Property and Freedom Society earlier this year. In his lecture about the nature of man, Professor Hoppe shows how argumentation is a category of action and how it serves as a conflict-free way of conflict solving and conflict avoidance. All argumentative speech is a category of action and as such is aimed towards a goal. All speech carries the implicit premises that there are constantly operating causes and properties of things in reality that one can truthfully make reference to, and that all argumentative speech aims towards agreement about external reality. What is then the ultimate motivation of arguments, claiming that all knowledge is hypothetical and that no rational ethic can be validated and justified by our knowledge of the nature of man and the universe? It is the abolition of ethics altogether, with the exception of arbitrary and aggressively enforced ethics. To illustrate the disingenuous contradictions of the empiricist moral skepticism, let me quote from Professor Hoppe's Introduction to the Ethics of Liberty by Murray Rothbard. Quote, "For in claiming ethical questions to be outside the realm of science, and then predicting that property rights will be assigned in accordance with utilitarian cost-benefit considerations, or should be so assigned by government judges, one is likewise proposing an ethic. It is the ethic of statism, in one or both of two forms. Either it amounts to a defense of the status quo, whatever it is, or on the grounds that lastingly existing rules, norms, laws, institutions, etc., must be efficient, as otherwise they would have already been abandoned, or it amounts to the proposal that the conflicts be resolved and property rights be assigned by state judges according to such utilitarian calculations." A concrete insight about the origins of moral skepticism, historicism, and empiricism as applied to political philosophy may therefore be drawn from the necessary praxeological implications. Namely, that anti-scientific, morally skeptic theories have the inherent goal of dominating the discourse and justifying statism, a goal different from peace, defined as the absence of aggression, and that as such, these particularistic rules require not only the rejection of moral universalism, but that the veil of objectivity they are presented in is patently false, as they are driven by a motivation and therefore not value-free or verify. motivation which does not even coincide with the Hobbesian, or if you will, classical liberal purpose of governance, the establishment of peace and civilization. We're told that since the phenomena that makes up the subject matter of ethics is not constrained by inexorable causal laws and is subject to the choices of individuals, one cannot speak of ethics as a science, as it has no deterministic predictive power and is subject to the differences in values among humans. This, of course, shows a misunderstanding of the purpose of ethics and of the nature of man and of knowledge. Precisely because humans act, that is, because humans can ponder between different courses of action and choose to act one way or the other, and due to the material limits of physical reality, that is, the fact of finite natural resources and the potential for violent conflict over resources, it becomes necessary to establish what types of actions are better or worse so that peaceful cohabitation or civilization can be maintained. If this were not the case, and all human behavior were determined by physically inalterable laws, such that all action would be predictable in the way that the decay of a nuclear isotope is predictable, then such a consideration would be rendered both impossible and meaningless due to the fact that one could not speak of actors, but instead one would be speaking of mechanically determined objects while being a mechanically determined object himself. This clear misunderstanding of the nature of man is a rejection of our knowledge of man. That is to say, it is the rejection of the possibility that something can be known to be generally true of all men. The historical, cultural, psychological context of the anti-science of moral skepticism is revealed as a program to justify and defend the ethics of statism. Now, anyone familiar with Mill's treatises on tolerance and liberty, and with Anglo-Saxon culture, will realize the prevalent aversion to speak in absolute terms. Everywhere one can find statements preceded by, in my opinion, and I think, yet the libertarian position is the only one that, in spite of being absolute, is bound by the non-aggression principle, therefore truly open to uncoerced examination. Let me quote Professor Hoppe again. Ultimately, the course of human history is determined by ideas, whether they are true or false. Just as kings could not exercise their rule unless public opinion accepted their rule as legitimate, so democratic rulers are equally dependent on public opinion to sustain their political power. It is public opinion, therefore, that must change if we are to prevent the process of de-civilization from running its full course. Let me now suggest an answer and strategy vis-à-vis the current morally skeptic status quo. First, the expressed repudiation of the anti-rational, anti-scientific philosophy of science of Humean, Popperian, nihilist statism, as grounded in its contradictions and historical emotional origins. The abandonment of a morally neutral, descriptive-only approach to science, where the only ethic is to destroy non-aggressive ethics as if by edict of the high church of objectivity. Second, a long-term view of the anarcho-libertarian political agenda, with the goal of spreading the aforementioned libertarian universalist moral theory to establish exclusively anarcho-libertarian secessionist movements across Europe and the West, for the foundation of an anarcho-libertarian homeland, for the peaceful declaration of secession of other anarcho-libertarian majority regions, and ultimately for the devolution of Western civilization to its legitimate owners, the taxpayers. Third, and also consistent with Hoppe's essay, What Must Be Done, the abandonment of notions of a widespread anarcho-libertarian majority during the transition phase to anarcho-libertarian civilization. Based on the Hoppe-Kinsella of argumentation estoppel theory, we know that if you appeal to argumentation, you acknowledge the legitimacy of my property. But if you appeal by use of aggressive force, you implicitly agree with force as a means of dealing with you. And by effectively using force, you become a technical problem to be solved, like a wolf or a bear. Therefore, no need for a full-scale, widespread anarcho-libertarian majority exists. As described in What Must Be Done, and what is necessary is the establishment of large enough concentrations to succeed and deal with such technical problems. Libertarianism has not been immune to the sanctimonious pretense of spectator-based neutrality and pedantry of institutional intellectualism. Everywhere, academic intellectuals want to be reformers and groundbreaking theorists rather than learned ideologues and communicators about what we know about anarcho-libertarianism. Elsewhere, the importance of anti-intellectual, anarcho-libertarian intellectual elites has been stressed. I would like to propose a libertarian canon, or a set of books and writings that should serve as the basis for a libertarian ideological nation. First, Economic Science and the Austrian Method by Hans Hermann Hoppe, A Theory of Socialism and Capitalism by Hoppe, Democracy, the God That Failed by Hoppe, Against Intellectual Property by Stefan Kinsella, Punishment and Proportionality, the Estoppel Approach by Stefan Kinsella, What It Means to be an Anarcho-Capitalist by Stefan Kinsella, The Ethics of Liberty by Murray Rothbard, and as an addendum for the study of Austrian economics, I would propose Man, Economy and State with Power and Market by Murray Rothbard, as it extends, includes and integrates the works of Menger, Mises, Böhm-Bawerk, as well as it extends economic theory by clearly analyzing the consequences of statist institutions in the market economy. Let me then suggest Judeo-Christian ideology should be regarded as a millennia-old example to be followed, or a success story of universalist, metaphysically based ethics, a story that delineates the kinds of commitment and strategy required for the establishment of a civilization-wide philosophy and the basis for its legal system. It's in this context that I would like to propose the establishment of something like libertarian private clubs, community centers, call it what you will, the local anarcho-libertarian gentlemen's association, the local libertarian charity, the libertarian poker club, a place for weekly community gathering, socializing, and the study and discussion of the aforementioned texts. As an alternative to political libertarianism and libertarian and minarchist parties in all places, such places would serve as a permanent source of cadre building, networking, and as a place for the study of the anarcho-libertarian canon. The first accusation that might be hurled is what superficial resemblance this may have with the modus operandi of religions. As odious as this might seem to some, akin to dogmatic fanaticism and missionary work, such a comparison is evinced as superficial and unjustified upon further inquiry and logical analysis of the arguments contained in the aforementioned canon, and once what is necessary to establish anarcho-libertarianism as the predominant cultural force and what is needed for the completion of its ultimate goal is understood. A strategy of ideological internationalism or cosmopolitan ideological nationalism then needs to be adopted, taking cues from the main ideological movements having had a lasting historical effect in Western civilization: Judeo-Christianity and socialism. Both Christianity and socialism appeal to an ideological, universalist, ethical dogma as the foundation of common allegiance, overriding natural tribal allegiance. Then they went on to become the culturally predominant default view. Both were led by an elite of verbal and analytic ideologues whose ultimate goal was social influence rather than academic prestige in intellectual circles. A mere appeal, though, to natural tribal allegiances as opposed to allegiance to a central government may not coincide with a libertarian project for a free society. It may be the case that most Flemish, Catalan, or Basque nationalists may be right-wing socialist statists. In such a situation, appealing to separatist tribalism might not prove helpful to a libertarian cause. Until the end of the state, the end of its welfare apparatus, and the establishment of libertarianism as the predominant cultural force, what the proper analysis of immigration should be has been illustrated by Hoppe in his Democracy, and I quote, "If the government excludes a person, while even one domestic resident wants to admit this very person onto his property, the result is forced exclusion. Furthermore, if the government admits a person while there is not even one domestic resident who wants to have this person on his property, the result is forced integration. Before secessions take place and an international anarcho-libertarian homeland or a series of libertarian stateless polities is established, agreement on universal principles must exist." Stressing the functional harmony of principled private property anarcho-libertarianism with religious and national particularism, fomenting a shift among separatist movements such as the Catalan and the Basque in Spain, the Celtic nationalists in Ireland, Scotland and Wales, away from left-wing and right-wing socialist ideologies and into anarcho-libertarianism, is crucial. The universalist, internationalist, and ideological aspect of anarcho-libertarianism must be stressed, at the very least until the foundation of the first anarcho-libertarian homeland. Until then, the path is clear. Every ethnic group, every influential number of people must be libertarianized. For this, though, the state-funded institutions and their philosophy of science must be discredited and their fallacious thinking evinced for the nonsense that it is. And an elite of dogmatic, anti-intellectual communicators must appeal to the authoritative status of the arguments contained in the aforementioned libertarian canon. What I am calling for is an intentional anarcho-libertarian agenda. What is proposed here is both principled and grounded in the nature of man, and consequentialist, as it defines the greatest good for the greatest number exclusively as peace, and it delineates the real constraints necessary to achieve it, namely the universal acceptance, respect, and enforcement of private property rules. As repugnant as such an ideologically dogmatist approach may seem to some, it is worth keeping in mind that it is our opponents, the statists, who talk softly and carry the big stick. We do not have such an advantage. Therefore, so long as folly reigns, the truth cannot be repeated enough. Anarcho-libertarianism needs to be the basis upon which a new European civilization, or if you will, libertariandom of nations is built upon. Thank you.
Sebastian.
Yes.
You use the phrase anarcho-libertarian homeland.
Yes.
Do you think that a piece of real estate is required for that?
I think that the best example is the state of Israel. The Zionists, it took them about 50 years to get their state. Now, of course, that is an aggressive institution, and historically it has been proven to continue to be aggressive to this day. But I think that
So that's a piece of real estate.
that is a cue to keep in mind. It took them 50 years to nag the British and the League of Nations into getting a piece of real estate. Now, of course, I would imagine that an anarcho-libertarian homeland would be constituted of private property.
To what extent do you think the internet can forego the need for a geographical concentration?
I don't think the internet is the answer. Recent Guardian leaks have shown that the very lines, the fiber optic lines of the internet are tapped by the governments. We know that companies like Google and many other companies are protesting because of data that they are forced to disclose and that they are also not able to comment on. I don't know to what degree microprocessor manufacturers are under the same regime, and that's the only real consideration I have about, for example, Bitcoin. And I have doubled my money 2 times speculating in Bitcoin. So I think that the principles and the agreement and the pockets, let me put it this way. Spain, Civil War, post-Weimar Republic, Germany. There is going to be a vacuum and it is going to be inevitable. The catalactics of nations show us that they're all bankrupt and there's going to be a rupture. And I think that once that political vacuum takes place, it's better that we take advantage of that historical momentum than another Hitler or another Franco or another Stalin. So.
Other questions? That's good. Thank you very much.
Thank you very much.
So, now we start again. Next speaker is Duncan. He lectures on Austrian economics and financial theory all around the globe, mainly within the world of investment banking. He's also the host of the Sound Money radio show for Casey Research, and the host of the Smart Metals radio show for the Hard Assets Alliance. How many of you know about the political past of Andy Duncan? From early youth until the age of 30, he was a man of the left, a devout Marxist. He originally became a Marxist after discovering Das Kapital in his local state library, at what he says was the tender age of 8 years old. Fortunately, he recovered from his illness. And he did more than simply recovering. He became a committed Rothbardian and a committed Hoppian. And there's hardly a better sign of political health than recognizing the truth and value of Hans Hermann's Hoppe natural order of the private law society. It is in the natural order of the private law society that the best values and ideals of traditionalist conservatism and libertarian anarchism become one, a coherent whole, a desirable social order, full of possibilities, full of future. Andy Duncan has spoken on the interesting subject of liberty and literature at a Property and Freedom Society meeting in Bodrum. He is the author of the historical novel Sword of Marathon, which was published last year under the pen name Jack England. And he is currently writing its sequel, Acts of Sparta, which is going to portray King Leonidas of the famous 300 in a completely new light. According to description, Jack England has a keen interest in classical history, mythology, and its relationship to language, and the world of Aristotelian economics and its later logical descendants. Perhaps Jack England tells us something about Andy Duncan. The name Jack England reminds me of Jack London, the well-known Californian writer who passed away almost a century ago. I don't know if there's any connection there. I wonder if Jack England has ever met Richard Blake. I think they would like each other's company. Andy Duncan's talk here has the longest and the most complex title of all the talks, The Necessary Evolution of the Evangelistic Importance of the Anti-Intellectuals. The talk also has a subtitle, The 7 Habits of the Highly Effective Evangelists. And in it, Andy has the modest aim of covering 5 million years of human evolution, as well as the modest attempt to predict the next 5,000 years. I'm sure the talk will illuminate the title. Andy Duncan, the stage is yours.
Thank you. So thank you, Oscar. First of all, it's a great privilege to be asked by Andy to come and speak here. And when he asked me to come and speak, I thought I'd come up with the longest title I possibly could. And then once I kind of started thinking it through, I thought it's more summarized by the subtitle there, The 7 Habits of Highly Effective Evangelists. Just like Sebastian, I'm not a professional scholar, and all of these kinds of ideas are purely my own. All the mistakes that I'm going to be talking about are my own as well. So let's go through these 7 habits then. So today I want to lay out a case for how the movement for liberty can evolve in the future. And this is to escape the grip of the malevolent mafiosi known as the global power elite. These 7 habits are, here we go, avoid seeking arguments with statists, stop attacking each other, and I shall go through all of these in kind of detail later on. Number 3, we should build an alternative culture. We should always try and push secession. A strange one here, this is kind of affected by my work with Casey Research. We should help develop space technology. Always, number 6, key here, support the Austrian school. And the best one is get rich and have fun. So, let's get into these things. Now, before I get into the 7 habits, I want to divide humanity into 3 unequal parts. Now, the first group of people I'm going to call the alphas. These are a group of immoralists. What marks them out is they enjoy wielding power for its own sake. They like leading other people. They like telling them what to do, and they like living on their backs. They also like laughing at the people who they live off. Some might call them sociopaths. They basically violate social norms, such as Professor Casey's commandments. They like violating those things. Some people call them titans, and you can really spot the big ones because they're called the Great. So Xerxes the Great killed thousands, hundreds of thousands of people. Catherine the Great, similar sort of thing. And Frederick the Great of Prussia, again, mass murderers. That kind of marks them out. But they love these titles. Other titles they like are like Lord Defender of the Faith. Now, in the modern age, we've got several examples. We've got Stalin, we've got Hitler, and we've got Tony Blair. Typical examples there. In fiction, we see these people too. So Voldemort is a typical alpha, along with possibly the devil, and obviously in the Hobbit film as well, Sauron. Now, I want you to imagine that there are 1 million of these people in the world, and they are our enemy. Not the intellectuals of the left. These are the enemy. Most of them are embedded somehow in government or behind the shadowy scenes of government. Some of them are private criminals. And I love this story. A pirate, once captured by Alexander the Great, and one of these mass murderers, highlighted the difference between these private criminals and the public criminals in government. Alexander asked of the pilot, "How dare you molest the seas?" And St. Augustine recorded the pirate's kind of elegant answer, "How dare you, Alexander, molest the whole world? Because I do it with a small boat, I am called a pirate and a thief. You do it with a great navy, and you are called an emperor." That's the difference between the private criminal and the public criminal. So that's the alphas. We then have the betas, who form by far the greatest amount of people, approximately 7 billion of these people in the world. These people are what you might call honest, kind of working people. They do what they consider to be honest things, even if they work for the government. To them, working for the government is the same as working, they can work for a marketing company, or they can work for a marketing department within a civil service department. To them, it's just a salary, it's just a job. They think they're being honest. All they're trying to do is survive. We then get to another group. I'm going to call these people the intelligentsia, or the gammas, to go with our alphas and the betas. Two kinds of gammas. We've got gamma class 1 there, represented by Mr. Marx, and obviously the fantastic group there on the right of the gamma class 2s. And I'm going to also call these people the Marxist type people, the socialists or the statists. I'm going to call them the intellectuals, and I'm going to call them Misesians, and the people on the right there, the anti-intellectuals. Now, there are far more of the people on the left there, maybe 100 million of these people in the world, and maybe about, I'm going to, just for ease of argument, 1 million of those fantastic people there on the right. Now, often with bad grace, the intellectuals on the left there, gamma class 1, they support the alphas. And for supporting the alphas pay them. They pay them civil service salaries, they pay them professorial salaries, they pay them to write lead articles in the Guardian newspaper, they pay them to work for the BBC, they pay them to be sociology professors at universities. What usually marks out these salaries is they're generally far higher than they would otherwise earn in a genuine free market, which is why they give their support to the alphas. So, sawdust is in the mind of these intellectuals. They just take their devil's money and they just run with it. And finally, you'll be pleased to hear, we're getting on to habit 1 out of the 7. The first habit that we need to develop, never waste time arguing with the intellectuals unless you're one of our kind of great people. So Professor Casey, Sean, yes. If we haven't got the argumentation, we haven't got the skill and the resilience, we should avoid arguing with the intellectuals or the alphas. If you argue with the intellectuals and you're not strong enough, you're just going to make them bitter and angry and make them even more statist, because that helps them solve the cognitive dissonance which is in their minds, and you're just going to make them worse. And you're going to waste your time, and you're going to get very, very tired. Now, deep down, I think they know they're wrong in their unconscious. So because even a baboon knows that Keynesianism is nonsense. I mean, printing bits of paper and giving it out makes us more wealthy. I mean, that's just absolute nonsense, of course. So let's get on then to the second habit. What about the people on the right then? A very, very small group of the Gamma Class 2. They were spectacularly successful for one of the first times in history for about 200 years ago. So we had Jefferson, we had John Locke, we had we had all sorts of, we had Richard Cobden in the UK in the Victorian age, and they were tremendously successful, created the United States in the plural as opposed to the singular. But they made a terrible mistake in the 19th century. The terrible mistake they made is, of course, Hopper's problem of democracy, and they supported democracy, and as a result they lost all of that tremendous traction they'd gained in the 17th and 18th centuries. But I don't want to talk about democracy because I think most of us are familiar with democracy, the God that failed. But the second habit then, what we've got to do is stop wasting time arguing with these people, and what we've got to do instead is invade what they consider their own territory, and that territory is culture. We must try and take on them in that game. And that leads us on to habit 3. If we cannot argue our case fantastically well, and there's only a few people who can do that, we should leave the best of us to do that, and we should go into these other things. So what we need to do is we need to invade culture, and we can do that best by creating works of fiction, comic book kind of artwork, elegant clothes design, theatrical works, podcast series, photography, and best of all, the creation of spectacular new cocktails. So Xandra, I want to see some fantastic cocktails from you in the future, rather than arguing with intellectuals. Just create this new kind of alternative culture. Now, one of my kind of beliefs is that even if you're a statist, like J.K. Rowling, who wrote the Harry Potter novels, anything that's created that's worthwhile is always done in the spirit of freedom. Even if you're consciously a statist, unconsciously, if you create a good piece of work, it will generally be full of the spirit of freedom. And we can see that there. We've got the independence and freedom on the left there, and we've got the state, and we've got terror, and we've got murder on the right there. So a fantastic set of novels, I think. I also think it's very strange as well that Hogwarts School of Wizardry also breaks down into the 4 classes of people. The Slytherins, who are they? They're the alphas, aren't they? We've got the Hufflepuffs, they're the betas. Gamma Class 1, that's probably Ravenclaw, it's a bit of a stretch, that one. And of course Gryffindor, Gamma Class 2, which is the heroes like all of us in here. I think we should remain conscious, unlike people like J.K. Rowling, and we should create this alternative culture consciously. We should know we're doing it. We're even seeing this, of course. What we're seeing, even though he's a lovely, lovely chap, is we're seeing much more Richard Blake, and that's fantastic, and we're seeing a bit less Sean Gabb, even though he's a spectacular chap. And I think that's wonderful that we're broadening our culture away from just the purely kind of academic. And we've got to do this more and more and more, because again, arguing with the intellectuals is a waste of time. It just makes them more resistant anyway. So what should we be aiming at? Well, for me, this is the kind of thing we should be aiming at. My favourite political movie of the 20th century was The Matrix, and I think if we can all try to create something that anyway gets towards this, I think we'll all be doing a spectacularly fantastic job. By the way, I don't count The Matrix Parts 2 and 3 in saying these are great films. They were terrible. I only reserve that for The Matrix Part 1, which is fantastic, mainly, of course, because of Carrie-Anne Moss and that tight leather suit she wore, which was amazing. So this is the kind of thing we should try and aim for, as she's aiming there at the agent's head. Now, coming on to my next habit, I love The Matrix. Why? Because it forms a perfect kind of analogy with the state. We've got this perfect symbol of this modern state, which I think is based a lot on the ideas of Niccolo Machiavelli, as first written down in The Prince. And we see a world in which the majority of people are happy to kind of be asleep mentally and to be slaves, and to have these parasites taking their energy, taking their dreams, and these parasites are laughing at them all the time as they take all of their energy. So even within our modern real world, many of the beaters will work as police officers, tax officials, NHS counselling awareness advisors, and think they're doing a great thing, and all they're doing is just propagating the ideas of the state and democracy into everyone else's heads. And Ayn Rand, of course, would call these people, these government check-collecting drones, as second-hand dealers in ideas. We need to tackle these first-hand kind of people. So, in return for this, these unearned salaries, they will generally just do whatever the alpha class want to do. Now, this class of alphas, they form the agents, the politicians, and all the senior bureaucrats running all of the major government departments. They go from one central bank symposium to another, from one Bilderberg meeting to another. They go through revolving doors from governments to corporations and back again. And we need to deal with those people. By the way, I don't believe in conspiracies, any conspiracy theorists here, but I do believe that there's a network, a loose contractual network between all of these people where they all mutually support each other. And that some people can see that as a conspiracy. I just see it as individuals working immorally together via loose contractual relationships. So how are we going to deal with these people? We've got this great alpha nexus that's formed. This alpha nexus, they play the game of empire. And they play the game of empire, so currently we've got a few cities vying for which shall rule the world. Washington, of course, probably Beijing, maybe Moscow, maybe Brussels even. And how do we escape their taxes, their regulations, and this slavery system that they've created for us? Now, some might say, we lucky few, we Neos, we Trinities, we Morpheuses, we've escaped this mental slavery, but I say that that's rubbish, because every time we have a drink, we ride an aeroplane, we flush a toilet, we are paying for these things with taxes, we carry these stupid bits of paper around, which are basically ownership. They own us, bits of paper to cross their imaginary borderlines. And we've got to keep working and working until every last tax man and woman, every last customs official, and every last government bureaucrat in the world is paid off and made to earn an honest living. When we've denuded them of the wealth they steal from us continually to oppress us, then we will have the right to rest. Now, I've got some good news. I can guarantee, you like this, I can guarantee the collapse of this world state. I can absolutely guarantee it. Okay, that's the good news. What follows next? Bad news, yeah. The problem is how long is that going to be? Is it going to be 100 years, 200 years, 1,000 years, 5,000 years? I don't know. I'm going to put that on the outside, 5,000 years. Now, you might think, that's impossible. How can this happen? Well, the modern state, again, has only really existed for these 500 years, based upon Machiavelli, based upon the fraudulent fractional reserve lending of the Medicis and the Borgias. And that fueled the British Empire with the Bank of England. When the Dutch took over England in 1688, Bank of England founded a few years later. And we still have the various offshoots of that, such as the United States singular, which is today's current imperial overlord. However, the mechanism which created this power also contains the seed of its own destruction, because they had to create fractional reserve banking to create this massive power. They then had to create central banking to keep fractional reserve banking going, which is a completely a volatile system which breaks down without central banking. And then in 1971, they had to move to complete global fiat money to keep central banking going. Without all of those things, they would have long since collapsed. And I think just like the Roman Empire, they have nowhere left to invade. They've got nowhere to strip from. They've stripped everything. And this paper money is going to collapse, as documented by Mr. Herr Detlev Schlichter in his book Paper Money Collapse. But there's a deeper problem for the state beyond that of managing money, because the failure of the state, which I believe is inevitable, is in the DNA of humanity itself. So if we take maybe one of the oldest states, the state of Egypt, this is 3100 BC. This is a guy called Narmer, primary alpha here, the first pharaoh of Egypt. And look at this person, this typical alpha, celebrating by having a kind of monument made to himself of smashing someone over the head. The perfect symbol of what the alphas want to do to us. They want to enslave us and they want to smash us over the head. A kind of image as well from 1984 by George Orwell. But the state remains a blip, even if you go back 5,000 years.
We've been around as humans. We split from the apes 5 million years ago. The states only existed maximum 5,000 years. Humans, what we are, I mean, there's people in the room who know this better than I do. Our last kind of evolution was 200,000 years ago, maybe 100,000 years. Some people even say 400,000 years ago. And we broke out from Africa 60,000 years ago. So, you know, we've been around a long time, and we've lived that entire time, 4,995,000 years as anarchists, and only 5,000 years as living under a state in a kind of widening and wider area. Yes, the odd alpha gene will have popped up in these kind of hunter-gatherer tribes for those nearly 5 million years, possibly as a gene to provide the necessary level of cunning and evil to defend yourself from other hunter-gatherer tribes. But one of the beauties of the hunter-gatherer existence was, if ever the alphas took over a tribe and became too much, what could you do? You could walk away. You just said, I'm going down the beach, I'm going over the hill. And people went as far as Tierra del Fuego to get away from these horrible relatives. They went as far as you know, Tasmania in Australia, and we walked away from these bad people for most of these 5 million years. So for these 5 million years, we've had free association for almost all of our time on Earth. And the time of the state, to me, is a complete aberration. Just like the current interglacial that we're living in is an aberration. We're in a 500 million year ice age, and we're in this tiny little short interglacial, and just like the interglacial will end and we'll go back into an ice age, the state is going to end and we're going to go back to our time, as you were saying this morning, as anarchists. So what helped create the state? What took us away from these people who could walk away from it? You can see there's an alpha there, isn't there? A couple of other, I think as well, the guy with a bow and arrow, he must be the gamma class too, you know, technology, cleverness, resolution. It was grass that helped enable the state, because about 10,000 years ago, the Earth cooled down and dried out, and lots of the woodlands and lots of the kind of large game animals of the Middle East, China, and Mesoamerica died out, and people had to turn to dry grass to survive. And this dry grass, of course, became farming, became wheat in the Middle East, rice in China, and corn in Mesoamerica. And then once people settled down, they couldn't move. And once you can't walk away, once you can't move away, then you become prey to roving bandit gangs who can lock you down, because where do you go? You can't leave your wheat farm, can you? You've got to stay on the wheat farm. You can't go away because you're going to die in the desert. So you've got to stay on the wheat farm. And it became easier to pay a tithe to these roving bandit gangs than it did to kind of walk away from these people. So what have we got now? Well, what we have is we have 206 warring bandit gangs of alpha states, and they're coalescing, as kind of Hopper's argument says. They're going to keep coalescing and keep coalescing until eventually they're going to form one super global state. What will this be? Called the United Nations. This is obviously from Firefly, the badge of the Alliance. So we now currently have nowhere to walk away from. The whole Earth is just a grid of tax slave states, and there's nowhere left to get away to. But I think we will get away one day. And when we get away, I think we'll be getting away. Some say it might be on the moon. You've got The Moon is a Harsh Mistress by Robert Heinlein, which says we'll break away on the moon. I don't think we'll get away from the moon or Mars. I think we'll get away once we're into the asteroid belt and we have personal, kind of realizable space travel. And once we can travel around by ourselves in space, we'll be back to being able to walk away from these criminals, these alphas. So a long way in the future. Lots of people have walked away. We saw Roman tax slaves crossing the Rhine. They got away from the Roman Empire. We've got cavaliers crossing the Atlantic to get away from Cromwell. They helped form the early kind of state of Virginia and got their liberty by walking away. Once the state can stop us walking away, like the East German government tried to do with the Berlin Wall, then we're trapped. But once we break down those walls, as the DDR wall was broken down, then we can get away from these people. And even after 50 horrible years of the DDR, once people could walk through that wall, the whole thing disappeared in days. Days. All those guns, all those soldiers, it disappeared in days when they couldn't keep people in anymore on the farm. And that's what 5,000 to me is an outside time. I hope it's 100 years. I hope it's 200 years. I hope it's 50 years. I hope it's 10 years. But I think 5,000 is a kind of outside. Okay, so I've done 3 habits, which I'll summarize at the end. Let's talk about the next 4 then. Now, we've got this DNA of freedom within us. We can all trace our descent from these kind of people who had this freedom within them. And what we've got here is we've got Saruman there. He's an alpha, of course. We've got the orcs on the right there. They're the kind of beta thugs, the soldiers. Now, the problem that the alphas had when they took over the world by one kind of farm at a time, they needed support from certain people, and the people they needed support from were the intellectuals. And what the intellectuals did is these people were needed to persuade the rest of us to stay on the tax farm. They needed to invent the religions, and the religions all said stay on the tax farm and everything will be better in the next life. They needed to invent all of the kind of accountancy systems and tax systems which were needed by the alphas to control the rest of us. So we had lots of those people helping the alphas and getting what they got back when they supported the alphas. They got back silver and gold and all the kind of possessions that they might have wanted. They became the viziers and the holy men. So the next thing that we need then is we need to reverse the kind of what we need to do is we need to reverse the super state that's forming. This is why we need to support secession. We need to help us free Scotland. We need to help free all Catalonia. We need to break Belgium in 2. We need to break Britain down. We need to break Britain down into Wales and then Cornwall and then the Free Republic of Oxfordshire, which I'll be the president of. That'll be good for me. We must always support secession to try and shrink this thing down. And we should shrink this thing down until we break it down into the countries and then the regions and then the towns and the counties until we get down to households and individuals. Now, obviously the alphas are going to try to fight secession all the way along, just like Lincoln did in the United States in the Northern War of Aggression, unfortunately successfully. But we need to keep working on this kind of secession idea. This brings me on to my fifth kind of habit, and this is we need to get out into space, so we should always encourage technology, particularly anything to do with miniaturization, space travel, or human survival in difficult environments, so we can get away from this massive Berlin Wall of the Earth's gravity well. The 6th habit, I'm getting to the end now, you'll be pleased, after lunch. We need to always encourage the Austrian school. As the great Yuri Maltsev might have said, we should always encourage the Austrian school, especially the principles of sound money, free money, mediums of exchange. Where's Roman? Is he here? Okay. Whether it's Bitcoin or whether it's gold or whether it's silver, we should all agree on our own mediums of exchange. We don't need to argue with each other about it. We should have freedom to choose whichever medium of exchange that we want. The new world is dominated by entertainment, novels, music, video, iPads, computer games. And what we need to do to help persuade those intellectuals, the Gamma Class 1s, to come to our side is not argue with them, but just build this culture which will appeal to them because of this cognitive dissonance which rules their minds. We can just build this culture and show them the future, show them freedom, and the best of them will come to our side of their own volition. We need to encourage them to come to our side. We don't need to beat them over the head about it. We need to just show them our ideas, and then they will come to us of their own accord. This brings us on to the 7th habit, and this is the German band, A New Form of Life. Is that right, Sandra? We've got to, while we're doing all of this, we should stop being so serious, and we should try to have as much fun as we possibly can. So have fun, and also, of course, get rich. Now, we all need to make money. We need to make lots of money individually. The reasons that we all need to make money, and we need to manage rock bands and make money managing rock bands, writing novels and making money writing novels, is because we need to protect ourselves in the future. We need to be flexible and independent, and we need to, too many of us in the past, we've talked about money, we've even been experts on money. Even Mises himself never really made any money. We've got to try to have fun, get rich, and fund the development of those who come after us. So that's why it's brilliant that people like Andy and Emma and Caroline have helped fund something like this that enables us to discuss things and meet each other and drink too much wine probably. And then we can talk amongst each other, and we're helping fund the development of new people to come after us. And if we spend some of that newly earned money on parties of quality, then who can blame us for that? So what could be better than creating a better world, getting rich and having fun at the same time? So here's the 7 habits again, just in case you lost them there through the speech. 1, never bother wasting time arguing with the intellectuals or the alphas. The alphas, by the way, will seek you out and destroy you if you become too much of a target, unless you're extremely strong, like just a few of us. 2, we've got to stop attacking each other. The enemy lies elsewhere. 3, we need to build an alternative culture of freedom. 4, we need to push secession. We need to break up this alliance, this global superstate, and shrink it down to the household or the individual. We need to develop space technology to get away from the Berlin Wall of the Earth's gravity well. We need to support the Austrian school, and we need to have fun and get rich. So, if you consider yourself an anti-intellectual, and I hope we all do in here, following my definition, if you want to bring forward the inevitable date of human freedom, whether that's in 100 years or 5,000 years, and if you want to evangelize liberty rather than just talk about it, then it becomes necessary and important that you evolve yourself towards these 7 habits or something like them, and then we will achieve liberty. And if that's in our lifetimes or in the lifetimes of our children, then that's absolutely fantastic. So I commend these 7 habits to this house. Thank you very much. Okay, we're doing any questions?
Sure.
Gerard?
And it was brilliant. I love every minute of it, right? I have to say, however, you've inadvertently plagiarized the first chapter of my new book.
Before you even wrote it.
No, I've written it. Okay. You're absolutely right. You cannot have the emergence of states until you have the emergence of wealth, and you don't get wealth until you get the agricultural revolution. And that's a given, right? And it's only then that the horizontal relationships that existed within human relations for 99.9% of human time suddenly become vertical. But Zola is absolutely correct. I mean, all of your points are worth focusing on. I just want to focus on the third one. This is going to kind of sound strange coming from an academic. Academics are the stuffiest people you ever know, right? I hate academics. Okay? I just happen to be one. Okay? I've loads of them. When I was in school, I hated teachers. I still hate teachers. Right? Okay? All my life I've hated teachers. I never really wanted to be one. I've never seen myself. So your third point is absolutely correct. There is a tendency to speak to the converted. We're doing that here, and there's a place for that, right? But we can simply, it becomes self-gratification. We simply meet in little groups, and we have these meetings, and then we all go away, and then we have another meeting, and we do the same thing over and over again. And while that's a relief to feelings and makes us all feel we're not completely weird, the trouble is it doesn't get the message out there, and that's what evangelism is all about. Now, you're correct. There are certain people whose minds you're never going to change. You need to, now, I believe in talking to everybody when it comes to it, but certainly when you reach a certain stage of mind, you're not going to make any change. Then you walk away, don't waste your time. Right? So I would say try it, and if it works, plant a seed, walk away, leave it go. Your third one, I think, is the most significant of your 7 points. Right? Because most people are not intellectual, most people don't read books, most people don't pay attention to long arguments, most people are not persuaded by reason. They're persuaded by emotion. So if you grab them by the emotions, the intellect will follow. Right? And therefore, what you said about building an alternative culture, through books, through novels, through poems, through television programs, through whatever it is, I think you're going to do it. The title of my autobiography is going to be "Everything I learned from the movies," okay, which is true. Okay, I mean, we learn of values through stories and tales, through heroes. All our moral values are communicated through stories, not through that. You don't learn to be brave by getting a lecture on bravery, right? You learn to be brave by hearing stories about heroes and people who stood up to resistance and people who stood against the mob when it was, and so on. That's how you learn to be brave, right? So the third point, all of your points I think are extremely valuable, but I think your third point is absolutely vital. And I would like to see much more along the lines of what you're doing. Production of books like the Sword of Marathon, which is a great book, by the way. If you haven't read it, read it.
99 cents on Kindle or £7.99 for the paperback.
Absolutely, yeah, there's a great review by somebody online.
Professor Casey.
No relation to me. It's a great book, but more of that, more films. In fact, there's actually a guide, somebody's guide to libertarian movies as well. You can get it in a book form, which is terrific. Get people to watch it. You can spread the message in this way much further than you can. Once people then are engaged emotionally, okay, then you can introduce them to the books and the works, and if they have any intellectual talent, we'll call. So Andy, that was, by the way, I picked up that picture. I was looking for a picture of Hayek online, and I picked that one up, but I was much too refined to put that one up online. Well done, brilliant.
He's got a lot more hair.
Yeah.
So there is a directory of movies that are libertarian?
Yeah, there is, yeah. It's
Does anybody have the reference?
God, I was actually just reading it before I came over. It's called Miss Smith's.
This is the best question session I've ever
had. So-and-so's Guide to Libertarian Movies. What I'll do is I'll send Andy the link, the title to it, okay? And you can disseminate, is that all right? I will do that. Sorry to take over. That was brilliant.
Great. I hate answering questions, so you filled in a lot of the time. That's good. Are there any other questions?
Andy, what changed your mind?
It was this cognitive dissonance. I read 1984 as a socialist, and George Orwell himself was a socialist. And I still was a socialist, but at the end of that, but something went wrong in my lower brain, and it took several years to come out. And then I read another book called An American in the Gulag. And then because I'd been supporting Stalin since I was 8 years old. I mean, my local state library was full of books on communism and the praising of communism. I mean, these were old books from the 50s and 60s, still in the library, still supporting communism. So I'd read all of those, I'd sucked it all in. I didn't really understand Das Kapital at the age of 8 years old, but I just kind of thought it answered all of the answers, answered all of the questions. But I built myself up, and what happens is you create a self-image as a socialist. And anything which challenges that, so it's like vegetarians go through the same, because I was a vegetarian, of course, being a socialist as well. A vegetarian eats rubbish, processed rubbish, then turns to vegetarianism, and for a while they get healthier, because eating whole foods makes you healthier. But then after 10 years or so, then vegetarianism starts destroying the endocrine system in your body. But by then you've adopted the mentality, who are you? I am a vegetarian. And nothing can shake you from being a vegetarian. You'll go to your grave as a vegetarian, probably earlier than most other people. Same thing happens to socialists. You're not Andy Duncan, who happens to believe in the ideas of socialism, you're just a socialist. And so it's really hard to break down. So you need to get inside and tap emotions. And it was 1984 that did it for me, really. I was kind of questioning, I was in the New Marxism Today movement run by Martin Jacques? And I was inside Militant Tendency, and then we all decided to take over the Labour Party, and we did, and we formed New Labour. And our kind of Trojan horse was Tony Blair, and we used Tony Blair as a Trojan horse to capture the state again from Margaret Thatcher, and we were successful in that. But then I formed my own business following Peter Mandelson's ideas. And then the state started sending me huge bills for tax because I was self-employed. I'm unemployable, I can't work for anybody, so except as myself. And once I started getting these huge tax bills, that also helped. You know, can you send us a cheque for £15,000? Why? What am I getting for this? So these basic questions, the intellectual questions of Orwell got me, and the basic questions of why do I need to give these people £15,000 in one lump, got to me as well. And then I discovered Atlas Shrugged. And right at the back of Atlas Shrugged was one mention of Mises, one mention. And this is before the internet. And I had to find Mises in a local bookstore in London somewhere. And I found this copy of Human Action. And then I read Human Action and I was converted just like that. Just like that. And then it's Rothbard, Man, Economy and State. And then before you know where you are, you're here talking to you now. So, but it took 10 years to change. 10 years. And any other questions?
Yeah, would you restate habit number 3?
Habit number 3 is build an alternative culture. So we've got to get into the heart. This is why the left occupied culture. This is why they occupied
Gerard expounded on this, but What does it mean? Write novels? What does it mean?
It means we've got to stop letting the left have control of culture. They control ballet and music and the BBC, and they control all these outlets. They control Hollywood. They're constantly pushing leftism all the time. The guy who got arrested the other day for telling jokes about Nelson Mandela, they want to shut that kind of debate down. The culture is of Nelson Mandela is a superhero, and he may or may not be a superhero, but just telling jokes about him becomes bad, and that's the left driving that. We need to create this alternative culture, and I think even the statists do that unconsciously anyway. They create these great works of freedom without really realizing.
So we need a guide to libertarian novels, and we need a guide to libertarian movies, and we need a guide to libertarian music.
Well, that's the kind of thing, but we've got to stop being over-intellectual about it and just then having intellectual guides. It doesn't quite work. Just read Richard Blake's books and then come up with your own ideas and then write your own novels. But if you can't do Professor Casey's books, writing biographies of Murray Rothbard, you're not up to that, then don't just give up. Do something else. Do something you are capable of. Writing songs, playing the guitar.
Sing the praises of things that exist.
Yeah, well, that's I think that's number 6, isn't it? Support the Austrian school. Okay. I think I'm done. Thank you very much.
So, as you may have noticed, Kurt Doolittle was not able to be with us today. So there's one speaker left. As you may also have noticed, we are not submitted to the dictatorship of the schedule. The procedure is loose and casual, for example in the Q&A sessions. But it was intended to be so. We thought that it would fit the organization, homely atmosphere. Still, the lawyer in me rebels against such procedural looseness. Our last speaker of today is Gabb, the heroic director of the Libertarian Alliance. Now, I'm from Iceland, and the word Gabb in Icelandic means hoax or swindle. Gabb, however, is no hoax. He's the real thing. He's a prolific and very interesting author, and in my humble opinion, among the most important intellectuals on our side, along with, of course, Hans Hermann Hoppe. They are the right kind of libertarians. One of the books by Gabb worth promoting is Cultural Revolution, Culture War, How Conservatives Lost England and How to Get It Back, published in 2007. Another is the Churchill Memorandum, published in 2011. Gabb is trained in law and history and has a doctoral degree in political and intellectual history. He has written for a few prominent libertarian and paleo-conservative websites, such as VDare and NewRockwell.com. In the early 90s, he was the economic and political advisor to the Prime Minister of Slovakia. I think David Cameron would do this country a great service if he would hire Gabb as his economic and political advisor. Will that happen? Well, Gabb is a regular speaker at the Property and Freedom Society meetings in Bodrum, and it is an honor to have him with us today. Now, before I let him have the stage, I will announce that there is no formal dinner tonight, but people are going to Couch and Horse, a bar nearby, and everybody is can go along. Everybody is welcome to join. And related to Andy Duncan's talk, I was told to announce that Miss Liberty's guide to film and video is available online, so you can Google it. Miss Liberty's guide to film and video. Sean Gabb will talk about Europe and the new British Constitution. Please welcome Sean Gabb.
Thank you. Well, after such a grossly flattering introduction, I am terrified that I shall fail to live up to the expectations which have been raised in your minds, ladies and gentlemen. And so while I'm getting my brain into order, what I will say is that my dear friend Richard Blake, the author of these books, among others, this one's coming out in 2 weeks' time, wishes to thank Jack England for such flattering reviews that he's given of Mr. Blake's works, and to remind you, on behalf of Mr. Blake, that Jack England is himself a novelist of considerable genius, and that his Sword of Marathon is well worth reading. With that commercial interlude over, let me begin. Thank you. One of the agreed points on the British right, but by which I mean that loose coalition of conservatives, traditionalists, and libertarians who are in opposition to the current order of things, is a strong dislike of the European Union. And our anti-European narrative goes something like this, though you'll pardon me if I somewhat simplify and parody it, but it goes something like this. These beastly libertarians, sorry, these beastly, Freudian slip, these beastly Europeans, they are destroying our free British Constitution. They are forcing socialism on us. They are imposing their police state traditions on us. These people did not have they did not have a Victorian period like we did. They did not have a proper Enlightenment. Many of them indeed didn't have a Reformation. And so we must cut loose from the European Union at the earliest opportunity so that we can float off into the pure stratosphere of classical liberalism and a bit of Toryism and a few traditional values. What I would like to do today, without saying that I think the European Union is a good thing, is to give a slightly more nuanced talk on the subject of our entanglement with the European Union. And the first thing that I should say about it is that that part of our narrative which blames the European Union for our progressive loss of freedom in this country is untrue. It is largely preposterous. It is as silly as those Americans in the Midwest who believe that the United Nations is sending black helicopters to take away their liberty. There is no truth in the proposition that the loss of our freedom has been inspired by or directed from Brussels. To give a couple of examples. Some years ago, we lost our protection in this country against double jeopardy. The common law tradition is that you cannot be tried twice for the same offence or what is substantially the same offence, which meant that you could be put on trial once, and if you were found innocent, if you were found not guilty rather, you walked free. A very important protection, very important indeed when you bear in mind that the state has unlimited financial and intellectual resources to bring against you, and most of us have very limited financial and very limited intellectual abilities. The fact that the state can do you once per crime is a great limitation on state power, and we have lost that protection. And many of my fellow libertarians, conservatives and traditionalists said, "Oh, this is all to do with European integration. This is, this is part of the Corpus Juris project, isn't it?" Well, no, it isn't. Because in France and in Germany, you cannot be tried twice for the same offence. In many European countries, they have bills of rights which make it either impossible or very, very difficult to try people more than once for a particular offence. Indeed, the Corpus Juris, this so-called European Union Code of Criminal Law, says that no one shall be tried twice for the same offence after final judgment is given. Now, it depends what you mean by after final judgment, but there are protections. In this country, however, in 2003, we lost our protection against double jeopardy. In the case of murder, or rather in the precedent of murder, because what has been done once in law can be done again. In the case of murder, you can be tried twice if new and compelling evidence is discovered after your acquittal. These words are interesting because I noticed a few days ago when I was looking through the Australian legislation that the Australians have also got rid of their double jeopardy protection, saying that you can be tried more than once for murder if new and if fresh and compelling evidence is discovered. And it seems that that wording is reproduced throughout large parts of what is called by the right the Anglosphere. Now, Australia is not a member state of the European Union, and yet Australia has abolished its double jeopardy protection with the same words as the English abolition of double jeopardy. Or we can say that these beastly Europeans, they have imposed on us this European arrest warrant, which allows us to be extradited without showing probable cause to face horrifying trials in God knows where. Yes, yes, that's true. But the most vexatious extradition treaty we have at the moment is with the United States. You know, the Germans and the Austrians do not allow their citizens to be extradited to a foreign country for any reason whatsoever. And so in these two cases of double jeopardy and the fact that we can be extradited at will to be gang raped in some American prison has nothing to do with our membership of the European Union. And I could go through loss of freedom after loss of freedom in this country. The Jimmy Savile mania, the child sex obsession, money laundering, all of these things do not come from Brussels. Well, money laundering might do, but I'll come to that in a moment. It is not Brussels which has reduced the number of jury trials in this country to a few high-profile cases. It is not Brussels which is imposing this press charter on us, which will impose pre-publication censorship for the first time in 320 years. It is not Brussels which is enslaving us. It is our own people. And if I were an American giving this kind of speech in the United States, I would say much the same about the machinations of the United Nations or the New World Order. The evil empire is not in Brussels, it's not the United Nations. The evil empire is the Anglosphere. The evil empire is the condominium of American, British, Australian, New Zealand, and other English-speaking ruling classes. And so what is so bad about the European Union? And I would say this. The European Union is bad for this country, and indeed for all the member states, very largely because it is a fig leaf. It is a fig leaf behind which the British ruling class exercises unaccountable power. The European Union in itself imposes very little on us. Let me give you an example. I did a lot of work on money laundering about 20 years ago, got paid for it, so I did a lot of work. Don't always go together, I must confess, but okay. In the mid-1980s, various British and American financial institutions got worried about financial deregulation. They could see a loss of market share coming up. And so they ramped up the panic over the trade in illegal drugs. And since there was nothing that could reasonably be done more to stop the trade in illegal drugs, they decided to go after the proceeds of the sales of drugs, to stop people from putting the proceeds of this trade into the banking system. And so there was a convention signed in Vienna in 1988, the United Nations Vienna Convention on Money Laundering and Other Offences, which instructed the signatory states to bring in strict money laundering laws. This was pushed by the British and American governments, which were in turn pushed by the financial interests in London and New York and other places. And the Vienna Convention found its way into a directive of the Council of Europe, in which the British government is very heavily represented. And this Council of Europe directive was translated into a directive of the European Union, and the directive of the European Union was first of all translated into British law by the money laundering regulations in 1991. And I remember at the time complaining to various government ministers about the loss of banking secrecy, the loss of financial secrecy in general, and the unpleasant precedents being set. And I was told by these people, oh, nothing we can do about it, dear boy, this is all European Union stuff. It's, you know, coming in from Brussels, we have no choice but to implement it. That's how it works. The British state wants to oppress us in a certain way, but it doesn't wish to do so to our faces, so it goes through a whole cascading series of international treaties, rather like pouring champagne into a tower of glasses. And eventually it works its way down into orders in council or various other kinds of secondary delegated legislation in this country. You complain to your politicians about this, you moan about compulsory metrication, and you're told, oh no, there's nothing we can do about that. It's all European level stuff, we can't do it. You moan about, you moan about laws against buying super strength vitamin pills, and it's all the same. Nothing we can do, it's all treaty commitments, treaty commitments. Yes, but who makes those treaty commitments? Indeed, who drives these treaties through at the international level? Largely the British state. And that is, in my opinion, the main objection to British membership of the European Union. Not that these beastly Europeans are enslaving us, but because the European Union is a fig leaf for our own ruling class to enslave us without having to look us in the face. That does not mean, however, that we should walk away from the European Union today. Yes, let us leave the European Union, but not yet. And the reason for that is that it is not true that simply leaving the European Union will allow us to recover our traditional institutions in this country and the traditional balance of power within this country. We have a ruling class which is committed to mass enslavement and various kinds of unaccountable power, and if they don't have the European Union, they'll simply use something else. I don't know what it is yet. Probably the International Postal Union, I don't know, but if you take away the European Union, they will find some other fig leaf behind which to enslave us. Now, one of the positive things about the European Union is that on the one hand, it enables our ruling class to enslave us behind the fig leaf of international treaties. On the other hand, the rules of the European Union have imposed certain procedural requirements on our ruling class which can be turned to our advantage and which have, in the past decade, been substantially turned to our advantage. And with this long introduction over, let me move to the next point in my speech, which is about the nature of parliamentary sovereignty. That until the past few centuries, legislation was not the primary source of law. Indeed, 400 years ago, although Parliament was the highest court in the land, it was the High Court of Parliament, and it was able to declare the law in certain instances, and had been used substantially by Henry VIII to create fresh law in certain limited respects, Parliament was by no means supreme. There is a judgment from Lord Chief Justice Coke in 1610, the case of Dr. Bonham. The facts are not enormously important. It's about the ability of a doctor qualified in Scotland to practice in England. There was a statute, an Act of Parliament rather, of Elizabeth I, which prevented doctors qualified outside the jurisdiction from practicing as doctors, not from being medical practitioners, but from calling themselves physicians. And Dr. Bonham took the authorities to court, saying that the Union of the Crowns in 1603 had surely made this an absurd regulation. And Lord Justice Coke agreed. He said, "As it appears in our books that in many cases the common law will control acts of Parliament and sometimes adjudge them to be utterly void, for when an act of Parliament is against common right and reason, or repugnant, or impossible to be performed, the common law will control it and adjudge such act to be void." And with those words, the Lord Chief Justice set aside an act of Parliament as contrary to reason or the law of nature. And so 400 years ago, we had a balanced constitution in which Parliament was the highest court in the land, able to declare the law and able in some cases to make new law. But this ability to declare and to make the law was in turn controlled by the common law. In turn it was subject to certain rules of natural justice or rationality or plain common sense. Over the next few centuries, this view of Parliament as limited in its powers disappears. Disappears completely. In 1885, A.V. Dyce, in his Law of the Constitution, said what was very largely the consensus even at the time, that Parliament was absolutely sovereign. Parliament could pass a law to make it a criminal offence to whistle in the streets of Paris. The fact that the law could not be enforced was irrelevant. Parliament could make the law. Parliament could make a law altering the laws of motion. Parliament could declare a new speed for light, and this would be enforced by the British courts. Parliament could pass a law to put to death every left-handed man in the country, and this would be the law. Parliament was absolutely supreme, limited by no considerations of natural right, or reason, or common sense, or reality itself. A strange doctrine, but this was the consensus view of the power of Parliament. And in 1885 it didn't much matter, because England was a country ruled by its traditional aristocracy, which did not push its luck. It was a limited government. Didn't have a written constitution and Bill of Rights, but it didn't matter, didn't need one. We had a rather cautious aristocracy which looked to the long term, and we were not led by mob orators in suits, as is unfortunately nowadays the case. During the 20th century, however, the ancient constitution fell apart, and Parliament began to use its absolute legislative sovereignty to pass all manner of terrible laws. I won't go into the ins and outs of this, but awful things were done by Parliament, have been done by Parliament, and are being done by Parliament. limiting the right to trial by jury, playing around with our fundamental procedural rights under the common law, censoring the press, doing this, that and the other. You get the idea. And the judges for the past 90 years have been worried about this. Is there any limit, they've been asking themselves, to what Parliament can do? Or rather, is there any limit to what Parliament will do? And in 1995, Lord Wolfe, who later became the Lord Chief Justice, gave a speech. And in it he said, you know, Parliament is sovereign, I do agree. However, if Parliament did the unthinkable, then I would say that the courts would also be required to act in a manner which would be without precedent. Ultimately, there are even limits on the supremacy of Parliament, which it is the court's inalienable responsibility to identify and uphold. They are limits of those modest dimensions, which I believe any Democrat would accept. They are no more than necessary to enable the rule of law to be preserved. A senior judge 20 years ago was openly questioning the viability of the sovereignty of Parliament. The English courts have been chipping away at this doctrine for several generations. The development of the law of judicial review is a very interesting subject to study, I must confess, though I won't go into it at the moment. The problem with all of this brave talk about limiting the legislative abilities of Parliament is that the common law itself says Parliament is supreme. I could quote dozens of cases, but here's one from 1942. Parliament is supreme. It can enact extraordinary powers of interfering with personal liberty. If an Act of Parliament is alleged to limit or curtail the liberty of the subject or vest in the executive extraordinary powers, the only question is, what is the precise extent of the powers given? Liversidge against Anderson, 1942. Wartime case. However, here's one from 1974, the Picken case. What is it? Let's have a look. In earlier times, many learned lawyers seemed to have believed that an Act of Parliament could be disregarded insofar as it was contrary to the law of God or the law of natural or natural justice. But since the supremacy of Parliament was finally demonstrated by the Revolution of 1688, any such idea has become obsolete. That was the reluctant consensus of the judges until the 1990s, no, until the early part of this century, when the European Union began to flex its rather puny muscles. You see, if the judges, under the rules of our own present constitution, were to say, Parliament cannot do this, the politicians would simply say, we are supreme, we are sovereign, we can do as we please. And they will undo the judgment by a fresh Act of Parliament. And since the politicians control the purse strings and the politicians control the guns, and since the politicians can tell us that they represent us, the politicians will win if they keep on legislating and re-legislating. There is a limit to what the judges can do. And then something wonderful happened. Now, the European Communities Act 1972, which got us into the European Union, says that any law which has been made or shall be made pursuant to our treaty commitments is the law in this country. No need for an Act of Parliament. European legislation can come into our law via the delegated legislation provisions of the European Communities Act 1972. And so in order for a European Union law to take effect in this country, there's no need for a fresh Act of Parliament. It is simply enacted under the secondary provisions of the 1972 Act. For many years, the government made sure not to bring out the full implications of this, because the full implications of it are that European law is supreme and that any Act of Parliament passed after 1972 which conflicts with the any Act passed after 1972 which conflicts or is inconsistent with our treaty obligations can be set aside by the courts. And for many years, the government was very careful not to bring out these implications. Then in 1985, the British government passed the Weights and Measures Act, which said that it provided a whole schedule of weights and measures which were legal for use in this country: the pound, the gallon, the ounce, the inch, the mile, the square foot, etc., etc. Then in 1995, the British government used its delegated powers under the 1972 Act to make it an offence to use the English system of weights and measures for the sale of any retail goods. It became a crime to sell bananas by the pound. Now forget about the anti-libertarian superficial meaning of this. In 2000, a greengrocer in Sunderland called Steve Thorburn deliberately broke the law by selling a pound of bananas, and he was taken to court by the Weights and Measures people of Sunderland City Council. Steve Thorburn then appealed against his conviction on the grounds that the 1995 delegated legislation, which made pounds of bananas illegal, was brought in under the procedure put in place by the 1972 Act, whereas the 1985 Weights and Measures Act made it legal to sell bananas by the pound. Therefore, the 1985 Weights and Measures Act had to some extent repealed the 1972 European Communities Act. Therefore, we had left the European Union. Now, this went into court and it worked its way up to the Court of Appeal. And everyone was enormously embarrassed about this because Steve Thorburn didn't care about his ability to sell bananas by the pound, the ounce, the kilogram, or by the scruple. It didn't matter to him. What mattered to him and his friends was that we were out of the European Union. And we were out of the European Union because Parliament had repealed the European Communities Act by accident. And the lawyers for the government and the lawyers for Steve Thorburn made what I thought were utterly preposterous arguments which avoided the issue. And it's not often that English judges proceed of their own motion. Usually judges will decide a case on the facts given them by counsel, and they will use the law as provided to them by counsel. On this occasion, the judges just threw out all the submissions they received, which were pretty useless anyway, and they made the law up as they went along. And I won't read the whole judgment because it's quite long, even the bit that I have here. What the judges said was, well, this is a mess, isn't it? This is how we're going to sort it out. There's a hierarchy of acts. Yes, I know that traditionally every act of Parliament is equal, but later acts of Parliament beat earlier acts of Parliament. But this is the law from now on. There are certain constitutional acts of Parliament, and we shall take the Magna Carta and the Bill of Rights 1689 as constitutional acts, though they're not acts of Parliament as such. We'll take the Petition of Right. We will take the Habeas Corpus Act 1679 as amended. We will take a whole range of fundamental laws and call them constitutional acts. The European Union, the European Communities Act is also a constitutional act. And although Parliament has the power to repeal these expressly, Parliament does not have the power to repeal them impliedly. And so, if Parliament wishes to abolish trial by jury, or if Parliament wishes to put every left-handed man in the country to death, it cannot do this by just sticking it into a local government bill and then letting it come out in the wash 5 years later. Oh no, the politicians have to stand up in Parliament and say, oh, and by the way, we're going to censor the press from next Tuesday. We're going to do that. They cannot do it by the usual roundabout means. If they are going to oppress us in future, they must do it to our faces. What the judges did in the Thorburn case in 2002 was to stage a judicial coup. They abolished the absolute legislative sovereignty of Parliament. And there was nothing the politicians could do, because the politicians, i.e. the Labour government, was absolutely committed to our European Union membership. And what the judges said to the government was, you win this case, we're still in the European Union. Oh, and by the way, your legislative sovereignty has just been taken away from you, thank you very much. That's the deal, take or leave it. And the politicians took it. And since that judgment in 2002, the judges have been pushing forward, warning the politicians all sorts of ways, if you pass this Act of Parliament, we will void it the first time it comes into the Court of Appeal or into the Supreme Court. Go and try your luck. You push this through, we'll void it. And there's nothing you can do to stop us, is there? And none of this would be possible without our membership of the European Union. As I said, when you have a doctrine as solidly based as the absolute legislative sovereignty of Parliament, in the hands of a government which controls the purse strings, controls the armed forces, and controls public opinion, there's not much the judges can do if it comes to a straight constitutional challenge. But because we are a member state of the European Union, and because the government is committed to working through the structures of the European Union to oppress us, the judges on our behalf have found a solid rock on which to place themselves as the ultimate controllers of what Parliament does to us. The judges have re-established in this country the doctrine of fundamental constitutional law which no Parliament can change. Now, I will not romanticise this. I will not say that the judges are secret libertarians or conservatives or traditionalists, though they are much more those things than the politicians, because they're not elected and because they belong to a traditionalist order, and because instead of these scumbag politicians who vote for something and then run away from it, a judge has to put his reasoning into words, publish them, and put his name to them, which means that they will be rather more cautious and rather less insanely illiberal than elected politicians. I will not romanticise the judges that I just have, but this is a step in the right direction, and it is a step in the right direction which would not have been taken without our continuing membership of the European Union. And so if we were to have a referendum next Thursday, in or out of the European Union, at the moment, I'm not sure how I would vote. I do believe that we must ultimately leave the European Union because it would prevent a traditionalist government in this country from doing most of the things that I regard as necessary for the recovery of our freedom. But at the moment, there is no chance of a traditionalist government. There is no chance of a domestic recovery of our freedom. And so I am very grateful that the judges in this country are working very hard to overturn the absolute legislative sovereignty of Parliament. And I am, to some extent, embarrassed, but also grateful that the rock the judges have found on which to base their overturning of this absolute legislative sovereignty is our membership of the European Union.
To what extent can English judges avoid European law at the moment?
Well, they can't, because European law is supreme. However, European law mostly does not affect us. It comes down, it cascades down to us via various statutory instruments and orders in council from the British state. And yeah, but you see, the institutions of the European Union are far less malevolent than the institutions of the British state. The British state is run very largely by certifiable lunatics, whereas the institutions of the European Union are controlled by 28 or 29 member states not all of which are run by certifiable lunatics.
Sean, you touched on the Anglosphere, and one of the things that I've always been concerned about since I moved here was the seeming American influence on England's structures, infrastructure, law. How do you think Parliament shooting down the invasion of Syria has changed that relationship?
Although many of my dearest friends are Americans, it sounds like I'm about to be my anti-Semite, as I say. Some of my best friends are Jews, but some of my best friends are Americans. But I certainly don't like the United States, and I regard the United States government as the central committee of the evil empire. And so I rather like President Obama because he is openly anti-British. He doesn't like us, and he also doesn't need us, and he doesn't want to run crusades to bring democracy and apple pie to God knows where in the Middle East. And there is a certain parting of company between London and Washington, which I find entirely welcome. Indeed, I think I began to reconsider my Euroscepticism, not after the Thorburn judgment in 2002, but after the Iraq War in 2003. I suddenly realised that the European Union seems mostly obsessed with setting maximum sizes for vacuum cleaner bags, whereas the American-British New World Order is interested in bombing its way throughout the world.
Well, I've for a long time believed that radical decentralization is a good strategy to advance our cause. But what your suggestion seems to compromise that strategy, doesn't it? My question is, what do you think about radical decentralization as a strategy? And do you think that the benefits from that you're mentioning from staying in EU outweighs the harm?
I believe that if we left the European Union tomorrow, nothing would be done to tear down the structures of absolute and arbitrary power which have grown up in this country. Instead, without any external check on them, except a bit of egging on from Washington, our own authorities would immediately bring into place the most appalling laws. At the moment, if the British state wants to oppress us, it needs to coordinate its actions with the European Union, and as I said, not every other European Union government is run by malicious or certifiable lunatics. Radical decentralization sounds a very good idea, so long as you can get it. But you see, if the United Kingdom was to leave the European Union tomorrow, that decentralization would simply move us from the vague control imposed by our judges via Brussels under the absolute control of supposedly elected politicians. And so it depends on circumstances. You see, was the breakup of the Habsburg Empire a good thing? That was decentralization. Looking at the history of Central Europe after 1918, there's not seen much of an advertisement for radical decentralization. Decentralization, yes, it can be a good thing. I'm sure in the United States, a lot of decentralization would be good. I'm sure in this country, a lot of decentralization to the counties and towns would be a good thing. But decentralization from the European Union at the moment to the United Kingdom, not such a good thing.
Any other questions?
Thank you very much.